Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Get your bingo cards ready at tcfbingo.com, and we will start our day with Judge Elmore, who appears to, he and his court are just having a little bit of a Monday, I think.
What we do for final pretrial conferences is those are generally about 10 days to 2 weeks before the scheduled trial date. When we get to a final pretrial conference, that's the last date in which I will accept a resolution other than going to trial or pleading straight up as the person's charged. So in other words, that's the last day to enter a pretrial agreement. Now, that's never to punish the defendant or to force the defendant to take a plea. I do that because I'm forcing the attorneys to do their job. Because once we have a trial date set, we have to send out letters to 60 to 90 different jurors. They've got to make arrangements and get child care, elderly care, take time off of work, whatever. Also, we have to subpoena witnesses. And sometimes those witnesses are coming from out of town. And they have to get babysitters, things like that, time off of work, take away from other duties. So it's never to pressure a defendant. It's just to pressure the attorneys to do their job. So that way they don't leave that day thinking, ooh, I'm going to show up in trial day and get a better offer. Nope, that's the best offer you're going to get, theoretically. So just want you to know how the process is going. They told me we don't have a resolution. The case stays on the trial docket. And I can tell you at this stage, I don't really know anything else about the case other than what you're charged with. Okay. I don't get to know what the witnesses, what the witnesses are going to say, what the allegations, all I know is what the allegations are. All right. So we are adjourned for that today, and we'll see you in a couple weeks. Anything else, sir? Yeah. Mr. Romero, go ahead.
I would personally like to apologize for being late this morning. I thought that you held circuit in Cadillac, so
it's okay. I was a little late today too. It's Monday morning.
Oh, you didn't know? I'm exposing myself for no reason.
Yeah, you just dimed it on yourself. I don't know what to tell you.
Well, you can't fault me for my honesty.
I guess not. No, you're all right. For pre-trials, I scheduled for 8:30 because we had a problem. Not a problem. We'll call it an opportunity to fix things. To ensure the attorneys had the opportunity to meet with you, so the jail got inmates over early enough to allow the attorneys to have a meaningful opportunity to speak with the defendant and the other side. So even though I told y'all to be here at 8:30, I knew I wasn't going to be here until 8:50 because it's really to order to make sure you guys have that opportunity to talk. So, all right. Thanks for letting me know you were late. Don't do it again. All right, thanks a lot. We'll see you folks. All right. And now we should be, and we also have done the pre-trial back with Alyssa Holiday. She's excused. And Stickles, that was done in chambers. That's excused. Okay. All right, so now we are taking up the case of People of the State of Michigan versus Brent Thompson. This is going to be case number 24-3532 FH. Appearances, please.
David DeHunt on behalf of the people. Robert Champion appearing on behalf of Mr. Thompson, who's appearing by Zoom from 06.
All right, Mr. Thompson, you are somewhat in a darkened room. It looks like it's about as wide as a locker. But anyways, are you able to see and hear me? No, you're not even moving. Mr. Thompson, can you see and hear me? Can you move back and forth?
Let me put him in. Oh, he's dialed back in.
All right, Mr. Epstein there with you? Never mind.
Let me put him in the waiting room and pull him back in.
All right.
Can you hear us?
Mr. Thompson, can you hear the court? Can you hear me? I'm giving the international signal for can you hear me? No? Okay. All right, we can't hear him because he just coughed or sneezed. All right,
We were talking earlier.
sure you were.
We were. Mr. Thompson, can you hear us?
I think I know what's wrong. We're supposed to say it like the movie Frozen. Can you hear me? Do not. We'll just go ahead and recess there in place, Nancy. You don't need to keep typing whatever I'm saying.
Thank you.
Council, I know this is about removing the habitual.
Correct.
Um, what does that do to the guide? Does somebody give your PSIs available? I just need to know what it does to the guide besides bringing the top down.
That's all it does in this case.
With the guideline, yeah, but so it'd be what would the guideline? Probably was it a 10 to 23 before, or actually it would have been like a 10 to 28.
I think it would bring it down to 5 to 23. I'm trying to verify that.
Right. And even if I took off the half second, if I gave him the same sentence other than the bringing the top down, it would allow him the opportunity for,
Correct.
okay,
And that is what we are looking for, Your Honor.
all right.
Both parties are in agreement for that.
So,
We're not asking that the sentence be modified, it just gives him the opportunity.
yes,
And I did confirm 5 to 23 would be the change.
copy. All right. Mr. Thompson, can you hear us? I think you can. Appreciate that. Oh, there you go. Oh, right there. Shake your head. Yes. That's no, sorry. Yes or no.
Can you read?
All right. Well, for any court cam that is watching us today or picking this up,
We're
this
hilarious.
is funny stuff. All right. How
I'll
about
have
this?
Nicole,
Are you willing to waive his appearance if I give you what you're asking for?
I am, Your Honor. In fact, I had discussed that with him. I said
All right.
this was a formality.
Let's go on the record.
do I leave him here or put him in the waiting room?
Leave him there.
Okay.
We were back on the record for People versus Brent Mark Thompson. Mr. Thompson is there on Zoom. We know that he's live because I've seen him move, but he cannot hear us and we cannot hear him. I'm going to ask the council to make their brief summary of this argument. There's already a motion in the file, which I think there was actually even a draft order, a stipulated order signed by both parties, if I recall. Anything to add to what you've written, Mr. Champion?
No, Your Honor, and I advised the client that this was necessary because it is a resentence. He understands that. He would waive his presence for this.
All right, thank you. Anything else, Mr. Denham?
Very, very briefly, Your Honor. Opposing counsel and myself, we discussed boot camp during the plea negotiations. I said I would support that at sentencing. The PSI said that he appears to be eligible for boot camp. The court authorized boot camp.
Yeah,
Unfortunately, because the guidelines of NDOC, they don't allow someone as a HAB second to go into boot camp. So the people are just asking that the HAB second be removed. We believe that the sentencing in all other respects was appropriate.
I'm going to summarize. I didn't make the error. Defense counsel didn't make the error. Mr. Champion didn't make the error. And since the Department of Corrections probation officer is not here, we're going to blame that person, right?
Well, it's not published. That's the issue. And this is
Yeah.
what we discovered is that it's not a public a published item for anyone to find.
No. And realistically, because they also have their recommendations often reviewed by the Department of Corrections offices in Lansing, and so forth, and they have a supervisor. We're just going to note that it was we're correcting an error.
Internal error.
All right. And so the court will grant the motion, or it will withdraw the habitual offender second. That will bring the maximum down from 180 months to 120 months. And the court will reissue the original sentence, other than just bringing that top down.
Thank you.
All right. Anything else, Mr. Champion?
No, Your Honor.
Anything else, Mr. Denhausen?
No, Your Honor.
Okay. All right.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Monday. So yeah, they're off to a interesting start in Missaukee County, but good for them. Their spirits are high, even though they're running late and having Zoom issues and all of that sort of thing. Let's go to Florida. Wade Mercer doing his first appearances.
August 4th. And it is 8:29 a.m. We've got Sergeant Gross this morning. Good morning, Sergeant. Have you had a chance to play the first appearance video?
Yes, sir.
Great. Ladies and gentlemen, I'm Wade Mercer. I'm the county judge in Jackson County. There are 2 attorneys involved in every first appearance. Today we have 3. What we're going to do is I want to make sure you can see and hear all of them. I know you can see and hear Mr. John McDaniel, Assistant Public Defender at the jail. In our courtrooms, our prosecutor, and we have Mr. Turner appearing remotely for one case. So I'm going to ask Mr. Mitchell to identify himself, and then we'll ask Mr. Turner to do the same.
Jake Mitchell on behalf of the state.
Mr. Turner.
Joe Turner here for Coleman Tillman.
Thank you. Sarge, can you see and hear all of us?
Yes, sir.
Great. Let's take Mr. Tillman first so we can get Mr. Turner back to work. Mr. Tillman, good morning. Mr. Tillman, Mr. Turner is here on your behalf. You're accused of 1 count of violation of county probation. Mr. Tillman and Mr. Turner, I believe that there's been some text messages exchanged this morning on some tentative plea offer, but I believe that Mr. Tillman, based on the text I got from Mr. McDaniel just a moment ago, Mr. Tillman would like to talk to you more in private, Mr. Turner, about his options. So, Mr. Turner, what's your suggestions?
That sounds good to me, Judge. I don't know what your next private attorney pretrial is.
We have a case management docket coming up on
14th. 13th.
Yeah. We're going to give you the date, but Mr. Turner, if there's something agreed upon or worked out before then, obviously I do first appearances almost every day. So if there's something worked out, we can do it at first appearance any day with some advanced knowledge. The actual next jail date is. So we have August 13th, Mr. Turner, and then we have a September one. Would you like it put on the August one or September one for now?
Let's go ahead and put it on the August one for now. That should give me enough time to see him, and we'll know what we're doing.
Perfect. So we'll set it for August 13th, and that's at 9 a.m. And Mr. Tillman, Mr. Turner will be in contact with you. If y'all get something worked out that everybody can live with, I may see it first appearance before then. Mr. Tillman, do you have any questions?
No.
You do have no bond for the time being. Mr. Turner, anything else, sir?
No, Your Honor.
Thank you for appearing this morning. Have a good day. Mr. Mitchell, I didn't ask you, but do you have anything else?
No.
Next case we have is Timothy House. Mr. House, good morning. Mr. House, you're here because you've been accused of 1 count of driving with license suspended or revoked knowingly. Mr. House, your own probation appears out of Walton County. Mr. House, your mother is in the courtroom. I'm going to appoint the public defender's office to represent you, Mr. House, and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. House. He's going to plead no contest to the charge as listed. Understanding he's going to be sentenced to 4 months in county jail. We have 1-day jail credit, a $400 fine. He's waived his right to jury trial and call witnesses. This will resolve this case today. He also has it must not be in the NCIS system, but he's got a warrant out of Bay County for a driving license suspended revoked 2020 2844 CT with a $1,500 bond.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
That is agreeable with the state.
Mr. House, did you hear that agreement?
Yes, sir.
Mr. House, any questions about that agreement?
No.
And Mr. House, is that the plea that you would like to enter to resolve the Jackson County charge?
Yes.
Mr. House, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly. I'm going to find it's freely and voluntarily entered with the advice of counsel. A judge, you're guilty of that offense, sentence you to 4 months in Jackson County Jail. But you have credit for 1 day that you've already served. There's also a court cost and fines of $400. Mr. House, when you get near the completion of that sentence, usually when it gets down to a week or so, 10 days maybe, the jail will run a warrants check for you. If they determine a warrant is active at that point, then what they'll do is they'll notify that county to go ahead and come and get you. You probably will come back to first appearance. If it's something you haven't been seen on, they'll come and get you. On the other hand, if they don't have any warrants that come up, if you've been able to resolve them while you're here, then you'll be released when you finish your sentence. Mr. House, do you have any questions?
No, sir.
Let me see if your mother has any questions. Ma'am, do you have any questions? All right, Mr. House, wish you the best, sir. Jason Smith.
Yes, sir.
Mr. Smith, good morning. Mr. Smith, you're here because you've been accused of 1 count of organized scheme to defraud. It's allegations are a series of thefts from Walmart. Mr. Smith, there is probable cause in the complaint. I'm going to see if the attorneys have any additional information before I address your bond status. Mr. Mitchell, anything on behalf of the state?
Not at this moment, Your Honor.
Mr. McDaniel?
Your Honor, just that Mr. Smith works as a truck driver. As soon as he found out about it, he lives in Pinellas County. He drove back with the semi and parked it, got a rental car and drove up here and turned himself in. We just asked for some kind of reasonable release option.
He's not a conditional release candidate with his history, but he's certainly entitled to a bond as far as I can tell. Would he prefer a cash bond or a surety bond, Mr. McDaniel?
Cash bond.
Mr. Mitchell, any objection to a cash bond?
No objection, Your Honor.
Mr. Smith, given your history, I'm going to set you a $500 cash bond. You post that cash bond, sir, you'll be released immediately. Your bond has a condition, no contact with any Walmart while the case is pending. No, can't go to any Walmart, Mr. Smith. Sir, you'll get to use the phone in just a few minutes to try to post that cash bond. If you do, you'll be released immediately. Do you have any questions?
Yes, sir. Could I pay out of my personal account here?
If you have it there, yes, sir, you can post a cash bond out of your personal assets as long as you have cash. Yes, sir.
Yes, sir. Thank you.
All right. Wish you the best, sir. Next case we have is Gary Wilson. Mr. Wilson, good morning. Mr. Wilson, you're here on failure to appear in case 24-626 CF, as well as a detainer for Leon County. Mr. McDaniel has sent us a text or email this morning kind of explaining your situation. So I went through and I saw a motion to reinstate your bond in your felony case here filed by your attorney, John Young Roberts. And what that motion says is that you missed court because you were in jail in another county. And that was on an old case that predated your bond. And then you went to another county after that on another old case. So I think that's what's outstanding. Mr. Mitchell, what's the state's position on whether or not he should be entitled to have his bond reinstated?
We have no objection. I mean, it's pretty clear based on the motion and the facts of the case.
Thank you. Mr. McDaniel, that's your position also, correct?
Correct.
Mr. Wilson, I'm going to reinstate the bond you were previously on. There does not appear to be anything that you've done to violate your bond, and it appears you have a valid basis for missing court, which is that you were unavailable because of an old charge. Had you got a new charge, totally different analysis, but that does not appear to be the case. So I'm going to reinstate the bond you were under previously with the same conditions. So if the judge had a special conditions on your bond of no contact with a person or place, that still applies.
Yes, sir.
You will, as long as you don't have any warrants anywhere, you'll be released today. Actually, you can't be released today because you have this detainer for Leon. Mr. McDaniel's email says you've got a couple more days to serve for them. Is that right, Mr. McDaniel?
Correct. The detainer was until the 9th, so they brought him over early. So I suspect they'll I don't know if the jail plans on just hold him until the 9th or contacting Leon County. I'm not quite sure.
Yeah, and I don't know what the jail will do either. That'll be their call, but either they'll say, Leon County, we don't need him anymore. Y'all can come get him. Chances are Leon County's not going to come get you until after the 9th. They're probably going to let you stay there until you finish it. But if that hold is released, if that detainer is completed, you'll be released when it's completed. Just to make sure you report into your bondsman, let them know you're out and that you're still on bond. Any questions?
No, sir.
Wish you the best, sir.
Thank you.
Yes, sir. Daniel, I'm not sure if it's Berninger or Berninger.
Oh, Berninger.
Good morning, sir. You're here for first appearance. You're accused of violating terms of your county probation in case 24-686 CT. I'm going to appoint the public defender's officer to represent you, sir, and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, let's talk to Mr. Berninger. He's going to accept the offer. He's going to admit that he violated his county probation 24686 CT, understanding he was sentenced to 4 months in county jail. He'll have 8 days jail credit, remaining fines and costs on the case. He'll work off while he's in the trustee bay, and this resolved this case today.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. What was this credit again?
8.
8 days? Okay.
8 days. Mr. Goodson is telling us he did pay all his fines and stuff before the alleged violation by the arrest in the new county. Mr. Mitchell, is that agreeable with the state? I
It
think they
is,
were
Your
asked.
Honor.
And Mr. Berninger, is it Berninger or Berninger?
Berninger.
Berninger. Mr. Berninger, is that the plea you would, or admission you would like to enter, sir?
Yes, sir.
I'm going to accept your admission that you violated the terms and conditions of your probation in case number 24-686 CT. I'm going to revoke that probation, sir, sentence you to 4 months in the Jackson County Jail. Give you credit for the time you've served, which is 8 days. There are no additional court costs and fines remaining. Mr. Berninger, hopefully you can get you some extra gain time out there and get this case behind you. There's no probation involved in this sentence, so when you finish this jail sentence, this case is over with. Any questions, sir?
No, sir.
Wish you the best, sir.
Yes, sir.
We already seen Coleman Tillman. That brings it to Scarlett Williams. Ms. Williams, good morning. Ms. Williams, you're here for first appearance, ma'am, accused of 1 count of unlawful exposure of sexual organs, ma'am. There is probable cause in the complaint. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Ms. Williams. She's going to plead no contest to the charge. As listed, understanding she'll be sentenced to 6 months in the county jail. She'll have 2 days jail credit via $370 fine. She has waived the right to a jury trial and call witnesses.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Williams, did you hear that agreement, ma'am?
Yes, sir.
Ms. Williams, do you have any questions about that agreement?
No, sir.
Ms. Williams, is that the plea that you would like to enter to resolve this case?
Yes, sir.
I'm going to accept your plea of no contest then to the charge of exposure of sexual organs, ma'am. I'm going to judge you guilty of that offense. Sentence you to 6 months in the Jackson County Jail. Give you credit for 2 days you've already served, impose court costs and fines of $370. Ms. Williams, this is what's called a straight time sentence, and all that means, ma'am, is there's no probation involved in this sentence. Hopefully you can get you some extra gain time at the jail. As you know, you're on probation out of Bay County for battery, and you have the exact same charge already pending in Bay County. So if there's
Wait a
a
minute,
hold on you,
battery.
ma'am, I can hear you.
Your Honor,
Probation.
she's out on bond for the same charge in Bay, but she is on probation for a battery charge.
Is that what I said?
Yeah, I think it was just mixed up
Yeah.
right there.
So,
with
Ms.
her.
Williams, all I'm saying, ma'am, is if they place it, there's no hold on you right now. But if they place a hold on you, we'll see if it's still there when you get near the completion of your sentence, Ms. Williams. If there is, you have to deal with that. If you're able to resolve it, ma'am, during your time here, then good for you. But if not, you'll deal with it when you get through here. Ms. Williams, do you have any
Okay.
questions?
No.
All right, ma'am. Wish you the best.
Thank you.
And I have informed the county ASA that handles her case over there about this.
There was another one that we needed to let the probation know.
I think it
Which
was
one was it?
House at the top.
It was Mr. House. We need to let them know. He's on misdemeanor probation in Walton County. And that may have been it. Yeah, that was it. So, Mr. McDaniel, that's everything I had on my list this morning. Anything else from the public defender's office?
There's a warrant in Bay County for him for the same offense, 2020 driving my license suspended. So, it's got a $1,500 bond on it. Yeah, it is, obviously must not be in the NCIS though, because he's been arrested since then, been on probation and everything else, but it's out there.
Did you write that? Which case are you talking, which defender are you talking about now? House? So he's on probation in Walton, but you think he's got an active warrant in Bay?
He does have one. It's a driving my license suspended revoked 22844 CT.
Okay. So Sergeant, if y'all could check on Mr. House, I don't want him sitting here for months and months and then finding out that there's a warrant. So if you could check on Mr. House, if there is a warrant from Bay, we need to bring him up and first appear him on that so we can make him aware of that, okay?
Well, I just told him and all, but it's a warrant out there. I mean, that's, but it's not in the NCIS system. So I don't know if they really want him or not. It may be just local if he's in Bay County. I'm not sure because it's not in the NCIS.
That's strange. Bay County usually doesn't do local warrants, but I don't know. Maybe they have in that case. Mr. McDaniel, anything else from the public defender's office?
Nothing, y'all.
Sergeant Gross, anything from the jail?
No, sir.
Mr. Mitchell?
No, Your Honor.
And Ms. Williams, anything? All right, so let me check tomorrow's calendar. It's just, no, tomorrow is not a regular day. So Sarge, Judge Grover has it the next 2 days. So hopefully when I see you again, I'll be a grandfather. I'll probably have already whipped him by then. I plan on giving him his first whipping pretty soon.
It's a mini crossbow.
Yeah. Yeah. All right. I appreciate it. I'll be back Wednesday. Ladies and gentlemen, I do not, if you're watching by Zoom or YouTube, I do not know if they'll be on Zoom or YouTube the next 2 days or not, but I'm planning on being back Thursday for first appearances. And Mr. Mitchell and Mr. McDaniel, I'll be here tomorrow, but not until after about probably 9:30, 10 o'clock before I get here because I've got a daughter's appointment.
Alrighty, well, it sounds like maybe he's going to be a grandfather, in which case, good for him. Before we move on to the next court, let's take a moment and discuss the sponsor for today's show, Aura. So you guys know I've been talking about Aura for a few days now. They actually came to me and said, hey, we want to sponsor your channel. And I said, hold up, show me what you can do first. And they have. I want to read to you from my own Aura page, and I'm not going to put it on screen because there's some private data there that not everybody needs to see. But this is a list of companies where they have removed my data from online. And Aura is a one-stop shop when it comes to protecting yourself and your data online. So stop me if any of these companies ring a bell to you. Apollo Interactive, Audience Acuity, Catalyze, DeepSync, Demist, DTN, Exact Customer, Instant Data, Intent Macro, KB Synergy, Lead Space, Sage Stream, Lion Share Marketing, LiveRamp, Media Source, Porch Group Media, okay, Posty, Spectrum, Unearth Campaigns, All Web Leads, BDO, the list goes on and on and on. And none of those are places that I have any idea who they are, but they had my data. And what's more importantly, even if I didn't know who they were, Aura did. And they got my data away from these people, and I can tell already I'm getting less spam emails, less spam phone calls. It's just wonderful. So as I said, Aura is a one-stop shop when it comes to your online presence and protecting it. They've got identity theft protection, transaction monitoring, spam and junk email removal, antivirus. They've got a VPN. They've got a password locker. They can protect you against spam calls, which I've had a lot of benefit from. There's a lot of things that they offer, and the beauty of it is it's all in one place. You don't need 20 apps to do this. You can do it with one. And they're giving our audience a 14-day free trial to check them out. You have absolutely nothing to lose. Within the first 3 days, the amount of things that they were finding and the amount of data they were removing from me online was just amazing. If you go to aura.com/TCF, you get a 14-day free trial. That's more than enough time for you to see exactly what it is that's going on with you online and to start to get some of that rectified. Again, it's aura.com/TCF. You have absolutely nothing to lose, so go give them a try. It will definitely be worth it. I've gone beyond my trial with them. I'm a customer now. I think you will be too. Aura.com/TCF. Let's go. Let's go to Texas. Judge West, fashion show.
Card abuse. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I have spoken.
I need you to speak up since I can't see your face.
I have spoken to 3 prior to my arrest.
Okay.
Cannot afford what they're asking.
Okay. So here's what I'm going to do, Ms. Graham. I'm going to give you another opportunity to try to hire someone. Since you've made bond, I expect you to try another 30 days at least. So what I'm going to order you to do is talk to at least 3 others. If you've already talked to some, you know they all have different payment plans. They all have different prices. Bring me back the names. If you can't hire someone, bring me back the names of who you talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. So make sure you get that taken care of. Try to get someone hired. If you do get someone hired, bring the reset notice that you get today to that lawyer and they'll tell you what to do. All right, step in front of the clerk.
Also, I bought a monitor that I need at least for that in order to go and talk to attorneys.
Well, your monitor, it's not house arrest, right?
I really don't know.
So the bondsman must have,
Hold on. No. This is the one she has a new case and,
oh, no, we're not going to take that off at this time, okay? You're on probation. Actually, the first case, I'm sorry, you're on probation in that 23 case for credit debit card abuse. You've been charged with another. I think that is, you need to keep it on for now. And you, yeah. All right, step in front of the clerk, get your reset notice.
So I'm able to go to the attorney's offices?
Yeah.
Okay, I guess.
there were modifications.
Ma'am.
There were modifications.
Thomas Johnson.
Thank you. Get with your bondsman. They know. I've sent everything to them. Thank you. Bye-bye.
Bond will be forfeited for non-appearance and reset at 100,000. Tammy Farrell. Good morning. Are you Tammy Farrell? And Ms. Farrell, were you able to get someone hired?
Yes, no, ma'am.
Okay.
I did get three. I talked to three people and got them.
Who'd you talk to?
And Mr. Macon and Lauren Caruso and Brittany.
Okay, and so are you working?
No, ma'am.
Or aren't you working?
I just haven't been able to get a job. I've been applying everywhere.
All right, so I'm going to have you fill out some paperwork to see if you qualify for a court-appointed lawyer this morning. You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct. If you step in front of the clerk, she'll give you that paperwork. Sarah Henderson. Oh, okay. Yeah. Maybe we'll hold off on the forfeiture then. Good morning. Are you Sarah Henderson? And Ms. Henderson, did you get someone hired? Ma'am, shh.
Not yet.
Speak up. I can't hear you.
Not yet.
Okay, did you talk to some lawyers?
Yes, ma'am.
Who'd you talk to?
James Macon, Langston Scott, and Corey Rock.
And who?
Corey Rock.
Okay, so where are you on being able to get someone hired?
I switched jobs, so I'm working for the city. So I've been getting paid every 2 weeks.
Okay,
So I just need like maybe 2 more weeks or so.
okay. So thank you for doing what I asked you to, Ms. Henderson. What I'll do is I'm gonna give you a normal reset, which is about 30 days. Hopefully that'll give you plenty of time to get one of them hired. If it doesn't work with them, be sure and call some others. Bring me those names if you are unable to get someone hired, okay? Thank you. Step in front of the clerk. Jasmine Dempsey. Good morning, you're Jasmine Dempsey. And did you get someone hired?
Well, I called 3 people like you told me last time before when I was supposed to have a call.
Right, so like we said, you get a court appointed when you're in custody every time. But when you make bond, I expect you to try to hire one. So who'd you talk to?
One was Jason Nix.
Mhm.
One was Matt Dean.
Yes, ma'am.
Tracy Wilson and Kyle Walker.
Okay, and are you working?
No, ma'am, but I just had an interview today.
Okay, so with what?
At Georgia Rock Convention Center.
Okay,
So I'm just that my office is open, but I have also another one out here at Del Papa.
Uh-huh.
So I'm just trying to, you know.
So what I'll do this morning, Ms. Dempsey, if you want, is let you fill out some paperwork to see if you qualify for a court-appointed lawyer, since you've done everything I've asked, and then I'll take a look at it, okay? Step in front of the clerk, make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true. Valerie Hale? Good morning, you're Valerie Hale. And Ms. Hale, did you get someone hired? Who'd you talk to? Uh-huh. What was the middle one? Okay. All right, did you, are you working? Where you work? Okay. I don't know if you'll qualify since you work, are you working full-time? Okay, I'm gonna let you fill out some paperwork to see if you qualify for a court-appointed lawyer. Since you did what I asked, I'll take a look at it and then we'll go from there, okay? Make sure you fill it out accurately and completely because you're going to swear under oath that it's all true. Okay, step in front of the clerk. Devonta Holt. All right, Mr. Holt, next time you come to court, do not wear a jumpsuit. That is not the appropriate dress to come to court. Do you understand?
Yes, ma'am.
And Mr. Holt, in cause number 23-1230, this is your initial appearance. You're charged with evading arrest or detention with previous convictions from March 9th of 2023. Goodness gracious. Is that right? So since you made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, I just had came home, but I had caught that case. I was on probation and I had caught that case when I had violated probation. I seen the police. I had did like 2.5 years.
You did?
Yes, ma'am. And they didn't run the CC, but I had seen the police outside my mom's house, so I took off running.
Devonta Holt. We're gonna check on that real quick.
I just got out of TC this
When?
July 16th.
Of this year. Luke, he said he's just got out in July. Have a seat. The DA is going to look up some stuff and see if there's something we can take care of, okay? Don't leave the courtroom. Yeah, it's Devonta. It's on, you need a cause number?
I'm working on it.
Thank you. Michaela Markentile? Good morning. Are you Michaela Markentile? And Ms. Markentile, this is your initial appearance in cause number 25-0528. You're charged with the state jail felony offense of theft of property from May 28th of 2022 through June 4th of 2022. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, because I'm not working, I can't afford it.
Okay, why aren't you working?
I've been looking for a job. I went to an interview last week and I'm waiting to hear back.
So what I'm going to do is just give you a little bit of time to see if you can get a job and start saving up for a lawyer, and then we'll see where we get next time. So I'm going to reset your case about 30 days. In addition to trying to get a job, I'm ordering you to visit with at least 3 different attorneys. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to if you're unable to hire someone, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. And if you do get a job, bring me some proof of that as well, okay? Step in front of the clerk.
All right, Fashion Monday seems relatively tame there by their normal standards. Let's go to Michigan. We'll say good morning to Judge Simpson. He is doing preliminary exams.
Case of the people of the state of Michigan versus Cody Jolly.
Andrew Childers appearing on behalf of the people.
Mr. Jolly, today, are you gonna state your name for the record?
Yeah, Cody Lee Jolly.
All right, thank you. All right, Mr. Jolly, this is the date and time set for your preliminary examination, what we had set before. And since you're representing yourself at this preliminary examination, I'm going to once again apprise you that you are before the court on charges that allege that on or about August 10th of 2024 at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that you did make an assault on a prison employee or employment or an employee of a place of confinement. You understand that charge, sir?
No, could you say it more? Yeah, I understand, but I got the discovery here. I couldn't hear you there.
Okay. That is a felony punishable by up to 5 years incarceration, $2,500 fine plus court costs. You understand the maximum penalty, sir?
Yes, I do.
All right. And you're electing still to represent yourself?
Yes, I am.
All right. There's great peril in representing yourself. You need to be aware of that. The court won't treat you any better, won't treat you any worse by you representing yourself. I would further advise you that if at any point you wish to be represented by an attorney, then you should let the court know at that point. And I will do my best to arrange that you have an attorney to represent you. You understand that, sir?
I do understand.
Okay. All right. Are we ready to proceed?
Your Honor, the people are ready to proceed with their preliminary examination, and I did hear Mr. Jolly acknowledge on the record that he does have the police report now that was served, I believe, Thursday night or Friday by jail staff, and I provided the court with a copy of the proof of service. The people are ready to proceed. We intend on calling one witness when the court is ready.
All right, very good. And I do have the proof of service in the file, and you may proceed then, Mr. Tillman.
Thank you, Your Honor. The people would call Officer John Apple to the stand.
Sir, please come forward to be sworn.
You solemnly swear or affirm the testimony you're about to give be the truth, the truth, and nothing but the truth, so help you God.
Yes, I do.
Have a seat, state, and spell your name.
Hello, I'm Officer John Apple, JOHN.
All right, you may inquire.
Thank you, Your Honor. Sir, how are you currently employed?
I work at the Washington County Sheriff's Office and their corrections division.
And how long have you worked in the corrections division of the Washtenaw County Sheriff's Office?
Approximately 18 months.
Okay. Were you working in that capacity of August of last year, 2024, specifically August 10th?
Yes.
Okay. And you were working in the Washtenaw County Jail? Your shift on that time, on that day?
I believe it was noon shift. It was 3 o'clock to 11.
3 p.m. to 11 p.m.? Okay. Directing your attention to around 5 o'clock in the afternoon or early evening on August the 10th, 2024, what were your job duties in the Washtenaw County Jail at that time? What were you doing?
I believe at that time we were doing our meal pass, make sure everyone gets dinner for the night. In the specific housing unit we were at, it was a door-to-door feeding unit. So you work with a incarcerated individual, worker, or trustee, go door-to-door to meal pass.
Okay. And what specific block or area of the jail were you working at that
I
time?
was working at A block that also has our max housing unit and observation unit.
So it has max housing observation unit, and that is within the A block of the jail.
Correct.
Okay. And you said you were passing out dinner effectively?
Correct.
Okay. Are you familiar with an inmate by the name of Cody Jolly?
I am, sir.
Was that individual housed on that block at that time?
He was.
Okay. I don't know, Your Honor, is the screen that in front of Officer Apple the same screen that we're seeing, or is that screen black?
It should be this.
Okay.
Well, no, he is, yes, he is seeing what we're, I guess, primarily that, the one that's moving.
Okay.
Is the one that he's seeing, right?
Officer Apple, can you identify anyone on the screen in front of you that you recognize from that date of August 10th, 2024?
I can't, sir. I see an incarcerated individual, Cody John.
Okay. And can you describe what they're wearing on the screen so we know who you're talking about?
Orange pants and a white long sleeve t-shirt.
Thank you. Your Honor, may the record reflect identification of defendant Cody Jolly.
Record shall so reflect without objection.
So Mr. Jolly was housed on A block and that's where you were passing out meals on August the 10th of 2024?
Yes, sir.
Okay. What, if anything, occurred when you had an interaction with Mr. Jolly on that date and time?
When I approached his door and breached his door to pass him his dinner for the night, he asked me if he could have another tray. He was sitting on his bed in the unit at the time. I told him that, if I have any extras, I'll circle back to him. And when I turned to collect a beverage for him, he began to stand up, and I believed that he was coming to approach me to grab his drink. But at that point in time, he began to strike me in my head and face area. We got in a bit of a scuffle. I tried to gain control of Mr. Jolly. He kept delivering strikes to me. So I delivered strikes back in self-defense. Was able to gain control of Mr. Jolly to the point where I could get back to my radio and essentially call for backup. In the jail, we called an available officer call.
Okay. And I'm going to just unpack that a little bit, Officer Apple. So you passed Mr. Jolly his tray of food, and then you had turned to retrieve the beverage from the cart. And where was that cart located?
It was just off to my right, so it was almost right in front of his door. I had an inmate worker helping me pass trays at the time, so I turned to him to get the cup. As I faced Mr. Jolly, he began to stand up. Like I said, I believe he was coming to meet me halfway for the beverage, and he began to strike me.
Okay. Other than yourself and the inmate who was assisting you, were there any other corrections officers in that area at that time?
No, sir.
Okay. Did Mr. Jolly say anything to you as he stood up and began, I guess, to kind of advance towards you?
No, sir.
Okay. You said he struck you in your face.
Correct.
Do you have any idea approximately how many times?
3 to 4 times.
Okay. Do you recall, was that closed fist, open fist, slap? Can you give us any detail?
Close fit. So it was kind of towards the top left side of my head and my face.
And
Knocking my glasses off.
Okay. So kind of, you said left side of your head, above your eye. Is that a yes?
Yes, sir.
Thank you. After he struck you a few times, you were able to basically strike him back in self-defense and eventually get control over Mr. Jolly. Is that fair to say?
Yes, sir.
Okay. Did other jail staff respond to assist?
Once I got control of Mr. Jolly and was able to get back to my radio, during the scuffle, I got knocked off as well as my glasses. So I was on top of Mr. Jolly at the time, was able to recover my radio and get that call out, and then other officers did respond.
Okay. Did you suffer any sort of injuries from this?
Superficial injuries, bruising, soreness, no long-term surgical anything. I did get sent out to St. Joe's at the time, or the Trinity Health emergency room, and then I had to do a follow-up, make sure I didn't have a concussion or anything before I could return to work.
Okay. And just so we're clear, the Washtenaw County Jail, is that located? I can never get this right. Is that technically in the city of Ann Arbor? No, Pittsfield Township. Okay. In Washtenaw County. Thank you. I have no further questions, Joe.
All right. Okay, Mr. Jolly, do you have any questions for Officer Apple?
No, I do not. Not at this time.
You have no questions?
Not at this time. It's pre-trial right now at this time.
All right.
Your Honor, I have no redirect. I have no further witnesses and the people would rest.
All right, you may step down, sir. All right. Mr. Jolly, do you have any witnesses that you'd like to call?
I do not. Just to remember, this is pre-trial, correct?
Well, it's a preliminary examination, Mr. Jolly.
Okay. All right. I was told it was pre-trial, led to the last court date, and then he told me you were rescheduling it for pre-trial, and so I don't know where we're at in the process. It was my understanding these last 2 have been pre-trial.
No, they were PCC and then your preliminary examination, sir. And today is your preliminary examination.
Okay, so okay. So what is my next one then?
Well, I don't know yet. Do you have any witnesses that you want to call today?
No, I do not. I just
okay. Do I have a motion?
So Your Honor, my question was that it's been over a year and I'm just trying to get to pre-trial. And my understanding was these last 2 cases were both pre-trial. It's been over a year. And for some reason, we still haven't got the pre-trial yet. Can I ask you why?
Well, I can tell you that you had a competency evaluation that there was an issue with you participating in. And then there was always the issue of your participating in all of the proceedings as they were set. So the matter could not move until there was a motion that was filed by the people, given your reluctance to participate.
Okay, well, that motion was.
So Mr. Jolly, I'm not gonna sit there and argue with you. I'm here now with your preliminary examination. You don't have any witnesses. Do I have a motion from the people?
Yes, Your Honor, at this time, people would move to bind the defendant over as charged on the one count before the court.
Mr. Jolly, do you have a response to that?
I didn't hear him. Could you say it one more time?
Pardon?
I didn't hear what he had said.
Your Honor, the people would move to bind the defendant over on the one count before the court and ask this matter proceed to circuit court for further proceedings.
Do you have a response, Mr. Jolly?
So, okay, my response is to move it to circuit court. We're talking about conference then. Is that correct?
Pardon?
Or if we move it over to circuit court, then we're on to conference. Is that correct?
On to conference?
Is that, yeah, he just said move it to circuit. Does that mean we're on to conference? That was my understanding, was that we're moving to conference. That would also be my request too.
Well, I don't know what you're trying to say. All I know is that what the people have asked is that the matter be bound over to circuit court for you to stand trial there.
Right, which would be moving from here to conference, which is right before trial, correct?
You would have different proceedings before Judge Slay, yes.
Which would probably be conference, am I correct?
Sir, you will have different proceedings before Judge Slay.
Okay.
Do you have anything in response to the people's motion to bind over?
You know, I would prefer, my response is to prefer to move on to conference. That would be my response to that. And then I also have my own, I would like to request again. I put in the motions for jury trial, a 12-person jury trial. And I also put in my motion for the 45-day speedy trial. And I am also requesting those as well again here today. Motions were.
Right. The court has heard the testimony in this case from Officer Apple. The court does believe that the people have indeed sustained their burden of showing that the defendant was in a place of confinement, that he also then assaulted an employee of that place of confinement. And so for those reasons, the court would bind the defendant or find that the people have established probable cause that this offense was committed and that the defendant committed it, and the defendant would be bound over to circuit court to stand trial. Jolly, you're now proceeding into what will be your circuit court arraignment.
Right.
I bound you over to stand trial. I'm now going to conduct your arraignment regarding those proceedings. So I would advise you are before the court on a complaint that alleges that August 10th, 2024, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Washtenaw County Jail, that you did, being a person lawfully imprisoned in the jail, did assault a John Apple, who was an employee of a place of confinement or other custodian, knowing the person to be an employee or custodian, through either the use of violence, threats, violence, or dangerous weapons while you were awaiting trial, contrary to Michigan statutes. Do you understand what you are charged with, Mr. Jolly?
I understand what I was charged with this to do.
Okay, that is a felony. It is punishable by up to 5 years incarceration and a $250 or $2,500 fine plus court costs. You understand that, sir?
I understand that.
All right. I do also have to advise you that if you are convicted, law enforcement is to collect a DNA identification profile sample before sentencing or disposition if it was not taken at the time of arrest. You understand that, sir?
Yes, I do.
All right. How do you wish to plead to that charge, sir?
No, not guilty. I also.
All right. The defendant, having heard reading of the information, pleading not guilty, court will enter that plea. A pretrial in this matter will be set for
September 25th at 1:30 for Judge Slay.
September 25th, 2025, 1:30 before Judge Slay.
Okay, my request for jury trial, I requested a speedy trial already, and I did file these motions. Now, can you, is this where I bring this up again?
You can bring those up before Judge Slay.
I've already requested it before you, though.
I know. So what I'm indicating is that I am not making a ruling on those because I don't have to. First of all, in regard to any delay in these proceedings, Mr. Jolly, you were the cause of the delay. So I think that any reference you're having towards speedy trial,
There's a right to speedy trial.
it's really your issue. Your issue to a trial by jury is intact. You will have your trial by jury if that's what you wish. Again, you may raise all of these issues before Judge Slay.
I did request a 12-person jury also.
In circuit court, that's the way it rolls.
And so that's the way it goes to the speedy trial. I don't have what you're saying. I don't have a right.
You can raise that if you think that you have been denied that. My ruling is that there has been no violation of any right you have to a speedy trial, because any delay that has occurred in these proceedings is either an acceptable delay in terms of the competency, but also any other delay was a result of your conduct.
It was 30
that
days
delayed
ago
these
on my
proceedings.
request, Your Honor.
Mr. Jolly, I'm not going to sit here and argue with you. I'm telling you what my ruling is. You may raise that issue again if you like before Judge Slay. You will get your jury trial. That will all be set before Judge Slay, and you'll be able to proceed there. At this time, these matters having concluded, your bond is continued. Thank you.
All righty. Yeah, he made a great choice, and Judge Simpson is so disgusted he just had to end his stream. Thank you, Barbara, for donating the gift membership. Very kind of you. Let's go to Judge Stevens.
5-0 here in the queue. Does this mean that 1531 and 1532 will be dismissed as part of this agreement?
That's correct.
Okay, that's your understanding? Kenneth?
Yes, sir.
You are Kenneth Randolph.
Yes, sir.
Here with your attorney and the state's attorney. Ms. McNally, does the defendant waive a formal reading of this arraignment and this indictment? Can we proceed in summary fashion?
Yes, Judge.
In summary, cause number 24 CR 2050 alleges that on or about May 20th, 2024 in Jefferson County, Texas, you committed the third-degree felony of injury to a child or an elderly person. This is going to be an individual 65 years of age or older. Are we enhancing this
Yes, it is enhanced to a second degree.
to, by what? This paragraph 2?
Yes.
And paragraph 2 goes on to allege that before the commission of that injury to an elderly person charge that occurred on or about May 20th, 2024, this states you were convicted of the third degree felony of retaliation on August 29th, 2022 in this court in cause number 21-37356. So paragraphs 1 and 2 would constitute an enhanced third degree felony, or in other words, second degree felony punishment, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you're facing here? Agree agreement has been reached where you would be placed on deferred or unadjudicated probation. This can be up to 10 years in length. If I sentence you to 10 years of deferred probation, you can be dismissed in 1/3 of that, or 3 1/3 years. Do you understand?
Yes, sir.
If you do well, you gotta do well, and I dismiss all the time. And it looks like these two other cases, 1531, 1532, will be dismissed as part of this agreement. Do you understand?
So,
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
yes, sir.
How do you plead to this charge then? Guilty or not guilty?
Guilty.
This pad.
Yeah, mine's doing something.
Now it's showing widgets are unavailable. Do you even know what that meant?
Yeah.
I don't even know how that showed up. What do I hit to get rid of that? See, now there's it's marked up there. Yeah, it won't. See, it won't.
Yeah.
For some reason, it's got real sensitive when you touch with your hands on the side.
Yeah, I've noticed that.
Sixth try.
Okay, so if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And in this prior conviction in 2022 of this retaliation, this 3rd-degree felony, as it is alleged in paragraph 2 of this indictment, is this true and correct?
Yes, sir.
And are you pleading true and correct to that voluntarily?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it?
Yes, sir.
Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, state. So help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is hereby waived.
Yes, Judge.
I'm going to follow this agreement and find then, sir, you are pleading guilty and true to paragraphs 1 and 2 respectively, which constitutes a 3rd-degree felony and enhanced to 2nd-degree felony punishment because of the prior conviction. You are mentally competent to plead guilty and true to those allegations. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence from State's Exhibit 1 supporting your guilty plea to find you guilty beyond a reasonable doubt, but I'm not going to find you guilty so long as you follow the terms and conditions of probation here. The probation officer will go over these with you. Make sure you follow these. These are normal and customary, and actually most of these things or most of these requirements or conditions all of us have to follow. If you fail to do that properly, your probation could be revoked. You could then be found guilty and sentenced up to 20 years. So you don't want that. Anything else to add? Okay, here I'm tendering the probation papers. Do you understand what has happened today, sir? Okay, good luck to you and see the probation officer. Thank you. Thank you.
All right, let's stay in Texas, but head west to Judge Boyd.
Mr. Flores, today is your plea deadline date. Have you reached an agreement or are you requesting a jury trial?
I was in the SCR. Is there any way I could get another counsel to represent me?
All right, so let me explain some things to you. I've been a defense attorney. I've been a prosecutor. This is what I've discovered in I say my short time on the planet, but I'm in the twilight of my life because there's more time behind me than in front of me, unless I'm planning to live to be 120. I don't know if I want to do that or not. So this is what I discovered as a defense attorney. I would have clients, and let me just tell you, just, like the series, the Guns of Will Sonnet, no brag, just facts. When I would have a client, a lot of attorneys, as a part of our giving back to the community, we represent clients on the appointment wheel. What I can tell you is attorneys who are representing clients on the appointment wheel, they're not paid enough money for what they do. I wasn't paid enough money for what I do. But all of my clients, whether they were retained or appointed, they got the Cadillac service, right? I would have some clients that would get upset with me because they wanted their case dismissed. They would think that I would just be walking around with dismissals in my pocket and maybe I wasn't pulling it out and signing it for them.
That's understandable.
And I would tell them, look, I can tell the state, hey, your case is bad. This is the problems with your case. Maybe you should dismiss it. At the end of the day, if the state doesn't want to dismiss it and they want to roll the dice and go to jury trial, they can do it. Sometimes I would have clients, they would say, you know what? I want the state to offer me probation.
Yes.
The state would say, hey, I'm not giving this person probation. So the way the legal system works, this is how it works. Your attorney will review all of the evidence that's been given to them.
Yes.
When I was attorney, I would tell my client, hey, these are the good points about your case. These are the bad points about your case. If this witness is here, and if they testify to what's in the police report, state will have proved their case. Normally, right? And so then I would have clients who'd say, hey, go to the state. Let's see what they'll offer me. And I would go to the state. I would do negotiations. They would present an offer to me. And legally and ethically, I had to give that offer to my client. So I would come back and tell my client, hey, this is what the state is offered. Sometimes my client would say like, ooh, great, I'll take that. Sometimes my clients would say, hey, I'm not accepting that offer, but I'll accept this offer, which is a counter offer. Then as an attorney, I was legally and ethically bound to go to the state and say, hey, my client will not accept this offer, but this is what they will accept. Then the state, you know what they can say? All right, we'll give your client that. Or either sometimes the state would say, no, this is our offer and this is the only offer we're tendering. And then it would be the client's choice whether they accept it or not accept it. There would be some cases they would have my client on video in HDD. Their mom would have already given a statement and told somebody, that's my son on the video. And you know what I would end up telling my client? Hey, look, I am going to fight as hard as I can for you at trial. I'm going to force the case to prove their case. But maybe the only way you're going to be found not guilty, if God sends his angels down and tap 12 jurors on their shoulder and say, find this person not guilty, I have other plans for them. But I would always tell my clients, you need to look at your case objectively and look at it and then make a decision on whether you want to go to trial or not go to trial. What I can tell you is this attorney has tried cases before. What you're charged with, he's definitely tried these type of cases before. And so if you want another attorney, you are going to have to retain your own attorney. I'm sure the offer that he has tendered to is what the state is offering.
It's not that, it's one of the first offer they gave you.
No. Here's the thing.
Okay.
Your plea negotiations with the state are confidential.
Okay.
So you're not supposed to tell me what the offer was or what they're doing.
Excuse me. It's because I remember I had another attorney, but then I had two attorneys, which was, I don't know who to remember. And then, so he had the offer for me already. And then I had to get assigned to him because he
sometimes, let me just tell you, you know why?
The same offer that they offered me, he can't even go ask them.
You know why?
You know what I mean? Like, no effort is what I'm saying.
No. This is what I want you to understand. Sometimes people will be appointed attorney, and that attorney the level that they have on the wheel is like maybe a state jail. And that's what they've been approved to try. Some attorneys, they have not been approved to try third-degree felonies or first-degree felonies. So sometimes people will come to court and like yourself, they'll maybe have a second-degree felony or a third-degree felony or a state jail felony. And the state will make an offer based upon the state jail felony or the third-degree felony. Then out of the blue, another case will come down, and then that case will be a first-degree felony. And then the state will say, hey, he has another case that's a first-degree felony. We're not offering the same thing. You know, it's similar to if somebody is charged with unauthorized use of a vehicle, that's a state jail felony. You get appointed an attorney, and the attorney that is appointed to you is an attorney who's had the necessary trials to be approved to be appointed to a state jail felony. So everything's going fine. The state has made their offer. Then bam, a case gets indicted and it's a first-degree felony. Let's say it's an aggravated robbery, and that attorney will come to the court and say, Judge, I'm not approved to try cases that are first-degree felonies. So then you get another attorney, and when you get that other attorney, if the state were making an offer based on the fact that you only had a state jail felony, and now you have a first-degree felony, normally they're going to change that offer, and that offer change is normally not going to be in your favor. So it's going to be different. So the fact that you have this attorney here and the offer is not now different, it's probably about the new case and not the fact that he has done something differently.
It was all the cases.
Yeah.
And
Yeah.
I mean, but I understand what you're saying.
Yeah. So I will tell you, this is your attorney. Today is your plea deadline date. You need to let me know whether or not you've reached an agreement with the state. If you have not reached an agreement with the state, that is fine with the court. This is just a time where I give people your last time to perhaps come to an agreement. And then after that, you're either going to a jury trial or a bench trial. If you come to me for a bench trial, if the state proves its case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. And for me as a judge, whether you're charged with murder or state jail felony or criminal mischief, if it's a murder case and the state doesn't prove their case beyond a reasonable doubt, I'm finding you not guilty. If they prove it beyond a reasonable doubt, I'm finding you guilty because I'm just here to follow the law. You understand? So today you need to make a decision on whether or not you have reached an agreement with the state.
So I can't have another counsel.
No. Did you not hear what I said? No.
No, I heard you say.
Yeah, no, you cannot. This is your attorney.
Okay.
All right. So I'll let y'all sit and discuss it. And when you're
Thank
ready
you.
to approach, I'll take the matter up.
Thank you.
You're welcome. Who is here on Felicitas Cooper and Michael Cooper, who informed me that he's actually named after the basketball player?
You need them to come up to the.
Yes. So he is yes. So he's in Texas territory as a person being named after Laker.
Well, we have certain dear friends that are also part of our, one of our colleagues and Lakers fans too.
Oh, no, we would watch all of the games. When I was growing up, New Orleans Jazz had already moved to Utah. And people always wondered, why is it called the Utah Jazz? I'm like, because they're supposed to be in New Orleans. And then we end up having the Pelicans. So.
Or the Lakers from Michigan, right?
Yeah.
Oh, the Titans originally were still the Oilers when they were in Tennessee.
All right. So defense, the court had concerns about conflict of interest, but you all said that you would file file a motion stating that the conflict is waived if there is one. Okay. So could you pull the waivers for me, please?
Yeah.
Right, thank you. All right, so we are here today. And Nate, have you been able to contact the complainant?
She reached out to us in response to the last hearing, so she's there, yes. And we need.
Was watching it.
She's there, so we're in the middle of trial, obviously we can't do two trials at once.
Well, no, have you tendered an offer?
An offer has been tendered a while back, but yes.
All right, and you all are rejecting the offer? You want a jury trial? How long do you expect this trial to last?
I would take no more than 3 days if we have to. do.
Sorry, what?
Probably no more than 3 days if the trial has to take place.
All right, Norma, I need a reset jury trial, 2 days. And it's family violence. All right, September 22nd will be your jury trial date. And I'll need an acknowledgement of discovery, please. All right. Thank you so much for dressing appropriately for court. And once you sign the reset form, you're excused. And once you all have the acknowledgement of discovery, you all will be excused.
Judge, on that date, I'm already set on prosecutor pro tem on a murder in the 290. That's what I was checking.
Okay, let's see if it goes.
It's really old. Okay, it's just the one case that I'm still prosecutor on, and it's in the 290, just so you know. So if that one gets called up, there's nobody to step in, so.
No, I understand. But we do have him, but I understand. All right, so just have a seat. They're gonna give you a reset form. Thank you, thank you.
And after we turn those in, then we be excused.
Yes.
I still have the case.
All right, let's head back to Jefferson County. Judge Stevens has another contestant.
And we now call 25 CR 403. And Clyde Eugene Freeman is here with his attorney, Ms. McNally, and the state's attorney. Earlier, sir, it looks like you pleaded guilty to this indictment, charging you with the third-degree felony of failing to comply with sex offender registration requirements, and a pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it? State.
No, Your Honor.
None from us, Your Honor.
It's made a part of the record for all purposes. And the agreement here is that the defendant is looking at a 5 years imprisonment cap. So if convicted, he is looking at no less than 2 nor more than 5 years confinement in prison. He could be placed on deferred or unadjudicated probation and regular probation.
Sure, Judge.
He could be sentenced to no less than 2 nor more than 5 years confinement in prison. That could be suspended, and he could be placed on regular probation for up to 10 years. And am I right in all the options?
Yes, Your Honor.
All right. And everybody has reviewed this and no objections, so as well?
No objections, Your Honor.
It's made a part of the record as well from the defense.
Yes, Your Honor.
It's made a part of the record for all purposes. Go ahead, Mr. Freeman. What would you like to say, if anything?
I'd like to apologize for not having my responsibility for one thing. And I also want to let you know that I got some supporters out there that are willing to give me a job if I'm.
What would you be doing?
Construction work.
Yeah.
Yes, ma'am.
I believe it's with a submit, he does that does local construction. Perfect. Like, perfect.
I'll be on this. Just get out of the meeting. I go. Wow, what it is about this. Yeah.
You did complete your high school education? Did you?
I got a GED.
Yeah. You've done cement work in the past.
Yes, sir.
You've got certificates in welding and material handling. What's material handling?
Material handling as well. Like, shipping in, receiving in, shipping out.
Okay. Okay, the pre-sentence report is reviewed and made a part of the record for all purposes. Go ahead. What is the state asking for?
Your Honor, the state is asking for a 5-year TDC. Again, the sex offender registration requirements are there to protect the community. We know how serious these offenses are, and believe the defendant's been given a break by being given the cap here, and so we believe the 5 years is fair.
Okay. What's the defense say?
Well, Judge, I clearly disagree with the position of 5 years TDC. We are here asking you for probation today. He is very aware of the mistakes that he made that led him to the position that he is in now. He has accepted responsibility for those active decisions to evade his responsibilities. He knows that those are responsibilities that he will have to ensure are taken care of if he is put on probation. And he is positive about his ability to be successful in doing that. He has support on the outside. His family is from this area. He will have a decent paying job to help him work through probation and to ensure that he is successful at these things on the outside. So we are asking for probation from him, for him, Your Honor. Do you have anything else that you want to say?
Sure. All right. If nothing further, I'm going to find as follows then that Mr. Freeman, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty to this third-degree felony of failing to comply with sex offender registration. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt here. The battery died. I mean, there's nothing else that can happen to that machine. I'd be shocked. There's everything that could happen has happened on that machine. And so there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of failing to comply with sex offender registration. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years confinement in prison. I just want you to let that soak in for just a moment. You understand where you stand here on all of this. You've got 117 days credit. That's far short of being able to be paroled. You'd have to stay in there a long time. Now, what we're going to do is grant your attorney's request. I'm going to suspend this, place you, the confinement, place you on probation for 10 years. Do well, it'll get shortened. But you have a lot of requirements to do in this probation, not the least of which is make sure you are always properly complying with the requirements for sex offender registration, and because that'll get you quicker revoked than anything else. Also, there will be terms and conditions of probation, which are normal and customary for this type of offense. And you will register with the sex offender tracking program. You will also enter and successfully complete a moral recognition therapy class, which is a good thing all the way around for all people, but you and I both know what the background of this case is and why you were registering as a sex offender. And we're not going to, there's no reason to ruin everybody's day about it, but it's not a good thing. That was in the past. What's in the past, though, it said is never really ever in the past. You got to deal with it on situations such as this. Also, you must understand that this is a conviction here, even though you're not going to prison. This is your second felony conviction. Third one is catastrophic for people. So you've got everything to work for in successfully handling this probation. Get this back on the deferred. Give it to Rogan so she can shred it really fast. Well, that one can probably do more harm, I would think. That deferred, if you will revoke on that deferred, you'd be looking at up to 20 years in prison. So this, you're capped at 5 years, but nonetheless, you know what it's like. And this gives you an opportunity to take care of concrete work, get a trade, follow the rules, and stay out of trouble. Are you going to be able to do that? Good. All right. Just don't talk the talk. Good for you. Walk the straight line. All right. Please, we're gonna get your thumbprint, then please see the probation officer. Thank you.
Two more times.
Let's continue to bounce around Texas. We'll go back to Judge Boyd.
We do have our CLO, and I do believe defense and the state are ready to proceed today.
We're ready, right?
All right. Court is calling 2020 CR 11967, State versus David Galvan Signs. Can I have parties announced for the record for the state?
Duffy Pitlock for the state of Texas, Your Honor.
John Wilson for the defendant, Mr. Sines.
And are you Mr. Signs?
Yes, ma'am.
All right, Mr. Signs, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yeah.
It's the document that tells you what you're being accused of not completing. All right, did you review that with your attorney?
Yes.
You gotta have to speak up.
Yes.
Did you understand it?
Yes.
Are you the same David Galvan Signs who was placed on deferred adjudication in 2020 CR 11967 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on January 19, 2021 for a period of 2 years? Is that you? All right, state, you may proceed.
Violation of condition number 2, on or about the 15th day of July, 2022 in Bexar County, Texas, the defendant, David Galvan Signs, did then and there consume alcoholic beverages in violation of condition number 2.
How do you plead, true or not true?
Not true.
Violation of condition number 2, on or about the 22nd day of July, 2022 in Bexar County, Texas, the defendant, David Galvan Signs, did then and there illegally use a controlled substance, namely methamphetamines, in violation of condition number 2.
How do you plead to that, true or not true?
Not true.
All right. State, do you have any witnesses?
We do, Your Honor. The state would like to call CSO Brian Leesman, last name spelled Leesman.
All right. Any objection to the witness appearing by Zoom, counsel?
No, Your Honor.
All right. Officer Leesman, if you can unmute for me, please. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
My name is Brian Leesman.
All right, state, you may proceed.
Howdy, Mr. Leesman. Who is your current employer?
It is Bexar County Adult Probation.
And how long have you been with adult probation in Bexar County?
18 years.
And is it regular practice for you to read conditions of probation or deferred in court?
Yes.
Did you read conditions in this case to the defendant David Galvan Signs?
I believe that was done by intake, but I usually, when they come in, the first time, I usually go over all the conditions with them again. So I know this case happened 2021. Let me see. I'm pretty sure I'm pretty confident I went over all the conditions, but the intake should have gone over it with him when he did orientation.
So by the time defendant would have gotten to you, that would have been his second time hearing the conditions.
Yes, sir.
Speculation, Your Honor.
All right, that'll be overruled. You can answer the question.
Yes.
Do you have a date that those would have been read to the defendant, explained to him by you?
Let me go back in my chronos. It looks like let me see. Since this was such an old case, I kind of had to go back and look at everything. I know he had a motion to revoke issued early in the probation because I think it was for failure to report. So we didn't report for March and April of 2021, which is why I think there was a motion to revoke issued at that point. I can tell you when he did intake.
Would that be the day that he was granted probation?
Let's see, I believe they were doing it over Zoom during that time because of COVID. So it looks like, yeah, January 21st of 2021.
That was the date that you went over the conditions with probationer, correct?
That's when it looks like he did his initial intake with Jonathan Trejo, one of the intake officers, and it's chronoed in here that he went over conditions with him at that point.
Is there a note in the chronos of you going over those conditions again subsequent to that intake date?
Let's see. Actually, yes. Actually, I saw him I guess he came in on the 26th of January, 2021. Let me see. Actually, I believe he reported by phone. That was during the COVID-19, so they weren't coming in. I did chrono that. I said this CSO reminded the defendant of his conditions. We'll conduct a Zoom interview with the defendant next week. So yes, I did chrono that on January 26th of 2021.
Do you know if defendant was given a copy of his conditions after they were read and after he signed them?
Yeah, they get an email copy from Adobe, I believe, after they sign them.
Do you have a copy of the conditions in front of you?
I do.
The state would also ask the court to take judicial notice of the conditions, Your Honor. We're asking the court to take judicial notice that there is this contract, probation or was on it, and it was the vehicle that got us to the hearing today.
All right, any objections?
Judge, I haven't seen the document he's asking you to take judicial notice of.
Let me give it to you, counsel. It's in the court's files. At least it should be. Thank you. Conditions of probation that are in the court's file. Any objection?
Objection.
All right, the court will take judicial notice of the defendant's conditions of probation.
Mr. Leisman, what signature or whose signature do you see on that document, probation officer wise?
I see Jonathan Trejo.
And what date do we have?
I see January 21st, 2021.
Do we see defendant's signature on that document?
Yes.
What does the signature made by probation officer Trejo mean?
It means, I can't vouch for him. Usually I would assume it would mean that you read and explained the conditions to them.
If you had been the officer reading those and then you signed it, is that what your signature would have meant?
Irrelevance, Your Honor.
Overruled.
You may answer the question, sir.
Yes.
Do you recognize the defendant here in court today?
Yes.
May you please describe the defendant by an article of clothing?
Wearing an orange jumpsuit.
Let the record reflect, probation officer has accurately identified the defendant. Now, today we have alleged 2 violations. The first violation, on or about the 15th day of July, 2022 in Bexar County, Texas, the defendant, David Galvan, signs, did then and there consume alcoholic beverages in violation of condition number 2. In your chronos, what do we know about that violation? Do you remember that violation?
Let me go back real quick. Yes, it was a violation of condition number 2.
And so please describe how we would come to getting this violation.
The defendant would have submitted to a drug test, urinalysis, and come back positive.
Is this at a facility?
Yes, it's either in our office or it could have been at the RMS downtown, Recovering Monitoring Solutions.
And is this an appointment or would it have been random the day of?
This one I would have to see, but I know he was supposed to be taking weekly drug tests as ordered by the judge. So in this case, I believe he was just doing weeklies. And I'm pretty sure I ordered him probably maybe every Wednesday or Friday or something like that.
And on July 15th, 2022, what did defendant test positive for?
He tested positive for alcohol.
Is that a violation of his conditions?
Yes.
And how do we know that there was alcohol in that test?
It's what we get from the results for Recovering Monitoring Solutions.
And is any detectable amount of alcohol a violation?
I believe so. Yes.
The second violation the state has alleged is another violation of condition number 2, on or about the 22nd day of July, 2022. In Bexar County, Texas, the defendant, David Galvan Signs, did then and there illegally use a controlled substance, namely methamphetamines, in violation of condition number 2. Do you remember this violation?
Yes.
How many days after the first violation did we get this second violation?
Approximately seven days.
And do you know if it was done at the same testing facility?
I would assume it was definitely done through Recovery Monitoring Solutions, so through the same provider. Yes.
And what was it that defendant tested positive for on the 22nd day of July, 2022?
Methamphetamines.
Is that in violation of the conditions of his probation?
Yes.
And do you know if it was a blood or a urine test?
It was a urine test.
And how do we know that there was methamphetamines?
We received results from Recovery Monitoring Solutions that confirmed positive for methamphetamine.
Your Honor, the state passes the witness.
All right, defense, you may proceed.
Thank you, Your Honor. Mr. Leesman, just so I understand completely your testimony here. These records that you're reading about these violations, who input that into the chronology?
I have to see. I'm guessing it was me, but I know now. Okay, who filed the MTR? That was me.
Yeah, you've had a difficult time identifying the provider, whether it was in office or at the recovery contractor.
Yeah, Recovery Monitoring Solutions is in our office. Like, they conduct drug testing in our office. So basically there's different locations. There's a location downtown, and then they basically come to different offices around, our regionalized offices. So during certain days of the week. So every drug test has been through Recovery Monitoring Solutions.
So within Mr. Sign's file, is there some type of a result from that test that is attached? Is it a slip? Is it a document of some type?
Go back. I don't have anything scanned in here. I would have to go. There's nothing scanned into my system as far as the actual results. But if I go to the Recovery Monitoring Solution website, I might be able to find it. I think they reset their website though.
So you're basing the totality of your testimony today just based upon the chronology that's in the system in front of you. Is that accurate?
Yes, sir.
And you've said more than one response this morning, either I believe or I'm pretty sure. There's no amount of certainty to any of the answers you've been given, is there?
Like I said, this happened so long ago. As far as the, I'd have to go through everything to see exactly what happened. I'm kind of trying to understand why this is being contested, because, I mean, we're recommending terminate unsat, but I don't know. Yeah, I mean, I guess you could say I'm still, you know, a little confused with everything,
All right,
but
so let me help with the communication. So probation can make whatever recommendation they want to make. Defense and state can make whatever recommendation they want to make, but this is a contract with the court. And so probation, you may recommend terminate unsat, but the court may not do that.
Okay.
So parties have decided to proceed with a contested hearing. So it's the defendant's right to have a contested hearing if he so chooses. So that's why we're here.
I got you. Yes, ma'am.
Thank you.
Your Honor, I'll pass the witness.
State.
Your Honor, no further questions.
All right, is the witness excused?
Yes, Your Honor.
All right, thank you for appearing, Officer Leisman. All right, any other
Thank you.
witnesses state?
No further witnesses from the state.
Defense?
Your Honor, I'd call Mr. Sines.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
David Galvan Sines.
All right, you may proceed.
Thank you, Your Honor. Mr. Sines, you were placed on probation for possession of a controlled substance back in 21, just like you described.
Yes.
And you participated in probation and submitted to drug tests as requested.
Yes, I did.
This first allegation that on July the 15th, 2022, that you tested positive for alcohol, do you recall that visit?
I recall that visit. It was a long wait in the office there. I went to the store out at the corner and I bought a sports drink and some snowballs. Came back, they went to lunch, you know, at the testing facility. I went back and waited for them to call me in. I was standing outside. They had everybody standing outside and proceeded with my drug test.
And did they inform you that you tested positive for alcohol?
No,
Had you consumed any alcohol that day?
no, sir.
Were you, in your opinion, in compliance with the conditions of your probation?
Yes, sir.
How about the following week on July 27th or 22nd rather? They allege that you tested positive for methamphetamine.
Yeah.
Did they make you aware of that?
They made me aware by the probation officer saying that the judge wants to speak to me. And at that time I got scared and that's why I didn't go back.
Had you been using drugs at that time?
No.
Had you used drugs in the past?
Yes.
And when was the last time you had used drugs?
Certain numbers. I came from California.
So when
You
you
were
were,
in 2010 from California.
had you used since you had been arrested for the charge that you were placed on probation?
No,
Do you have any explanation how they could come up with a positive test those two times?
well, they're pretty sloppy. They were in test facility that, I mean, you give them your sample and they'd be handling very different samples at the same time.
It's your testimony that you do not believe you would have been positive with either of those testing.
No, sir. No, sir.
I'll pass the witness, Ron.
All right, any questions?
Just a couple, Your Honor, please. You do remember the violation from July 15th, 2022. Even though you weren't made aware, you know that there was an allegation you tested positive for alcohol that day, right?
After the fact, yes.
Yes. So you did go and get tested.
Yes,
You knew about your conditions.
yes,
And then a week later, you tested positive for a different substance, methamphetamine. Right?
yes,
And subsequent to that, you were scared because you knew the judge wanted to speak with you.
in the form that the probation officer told me, that the judge wants to speak to you. And I said, okay. He says, show up at court so date. I went and tested after that. I came clean. I tested again after that. And, that's when he notified me. I don't have no recollection of whether I was clean or not on the second time.
It's your testimony that subsequent to testing positive on July 22nd, you took another test and that one was clean?
Yes.
Your Honor, the state would ask, dependent on defense's objection, for the court to take judicial notice of the court summary provided by probation.
Any objection to the court?
No objection.
All right, could someone pass me the court summary?
Your Honor, I have one. It does have,
Well, let me ask you this. What's the date on your court summary, please?
it has 8/4/25 at the top.
Okay, yes, I don't have that one.
Maybe, oh, you've got one? Yes, thank
All
you.
right, thank you.
On page 2, Your Honor, at the top, and I'll look with defense. It shows, like what defendant described, a subsequent date, July 29th, 7 days after the positive test. Another positive test for methamphetamine. Did you not know that you tested positive subsequent to this positive test? So this is the first time you're hearing you tested positive again for methamphetamine.
But
Were you scared to go before the judge because you thought she'd know you were doing meth?
I was scared to go in front of the judge because I didn't want to go to prison.
Now, Your Honor, the state has no further questions.
Mr. Sines, when you say you were scared because you didn't want to go to prison, why were you afraid you were going to go to prison?
The judge had told me that if I was tested positive, that those are my conditions, that I only go to prison.
But do you believe that you should have tested positive in those instances?
No.
Did the fact that the test showed it and you didn't believe you were positive weigh on your mind at all in that determination?
Yeah.
How?
Because I know I didn't do any drugs. Where I stay with my wife, some people go, they were doing drugs there. I don't know how it got to me, secondhand smoke or whatever. I don't know how that works, but I know me, myself personally, I didn't touch anything. Sometimes I'd walk outside and go play with the animals, take the dog for a walk or something. And when I heard that Judge Owen talk to me, it just, I got scared.
That's witness.
Any questions?
No further questions, Your Honor.
All right, what has he done on probation? And what I can tell you, Mr. Sines, is normally, and if you think that I said something different, you can let me know. But normally what I tell people is look, you're on probation. If you violate the conditions of probation, potentially this is what you're looking at as far as range of punishment. I normally tell people, if you think it's going to violate your probation, don't do it. If you think it may be a violation, don't do it. And when I have people coming back to me and I say, come in on a compliance, because this is one of those cases where I said, so he won't have to pay for a bond. We will just do it as a summons and have him come in. And he didn't show. And normally when people are coming in for compliance, it's for the court to figure out what's going on in your life and why are you falling off track and how we can place you back on track. What the court is going to do, the court is finding violations of 2 and 2 true. State, what are you requesting?
Your Honor, the state originally was in line with probation and defense's recommendation for term and sat, but if we are to have the state's motion granted, we would ask for revocation and perhaps the minimum 2 years.
Judge, we would ask that it be terminated on SAT. I don't believe the evidence that here was credible. I understand you finding it true. But there hasn't been any other violations. There hasn't been any other crimes. Mr. Sines was scared because he wasn't doing drugs and he doesn't drink alcohol and couldn't understand how it could be positive and kind of felt the deck was stacked against him and he freaked out. And I don't believe he's a threat to the community. I don't believe he's a person that needs to go to prison. I don't believe that additional probation is going to.
Well, here's my question, and this is what I need to know. Part of what goes into my decision is this. Was he reporting?
Your Honor, the last contact we had with him was August 16th, 2022.
All right, so the last contact they had with him was August of 2022. Then my next question is, was the $60 paid to the Bexar County lab for testing?
I don't see that payment was made, Your Honor.
Was 120 hours of community service restitution completed?
No, Your Honor.
Was proof of employment provided?
I can check our system, Your Honor. That wouldn't be in the court summary.
All right. Did you provide to them that you had employment or did you not have employment?
Did not have employment, but I paid for my drug testing every time I went.
All right. So it appears to the court that you haven't done anything on probation. And that's where I am. That's the problem. I know that probation said they were recommending term unsat. You haven't done anything. And that is why I don't think it would be appropriate for me to terminate unsat, because otherwise, then why do we have a probation? He hasn't reported since 2022. Is there a reason for his not reporting since 2022? He hasn't had employment. Why isn't he reporting? And then the court tried to get him back in compliance so this could be all avoided and taken care of, and he didn't show. All right, this is what the court will do. The court is going to find you guilty, revoke, sentence you to 2 years in the prison. I'll give you credit for any time that you've served. Could I have a trial court certification? I don't have one. All right. Oh, just one moment. He just needs to do that for me.
Okay, well, she's muted herself and we wait for her to come back. I would like to take a moment and address the sponsor for the second half of this show. A new sponsor to the channel, Michael Groff, friend of the show, YouTuber. The beauty of this particular sponsorship is he doesn't even know that he is sponsoring this program. But don't worry, Michael, Beth will send you an invoice, so all will be good. In all seriousness, though, if you're not familiar with Michael Groff, go subscribe to his channel. I will drop a link here in just a moment into the chat. Michael does weather content. The majority of it is Arizona focused, but he's talking about doing more, and the more subscribers we get him, I think the more we'll encourage him to do more. And quite honestly, this guy deserves your attention. Just go watch one of his videos if you haven't before, and you will fully understand what I'm talking about. So please go check out Michael Groff. Support the people who support this channel, and as well, you can see him on this channel Tuesdays and Thursday nights. Sidebar, our news show, 8 p.m. Eastern, 5 p.m. Pacific. He is one of the panel members there. She is still muted and paused and whatever it is that she does. So let's keep an eye on that. I'll try to go back there. In the meantime, let's go to Judge West.
Speak up, please.
Oh, I said I wasn't able to afford to get to him.
So did you talk to some others to see if they charge different amounts?
Other two, and they all said the same thing. They both said a certain amount, and I wasn't able to do.
Are you working?
Yes, ma'am.
Where do you work?
Headaches.
Okay. So you need to save up and you need to try to get someone hired. I'm going to reset your case another 30 days. I want you to talk to at least 3 more attorneys. If it's not going to work with one, you need to talk to as many as possible. It doesn't have to be just 3. It can be 10, however many. Try to see if you can hire one. And if not, make sure you bring me the names of who you've talked to when you come back. And also I want to see a pay stub when you come back as well. Okay? Step in front of the clerk. Dalton Frisier. Good morning, you're Dalton Frisier?
Yes, ma'am.
And Mr. Frisier, this is your initial appearance. In cause number 250404, you're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from February 6th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Did you get someone hired already?
No.
Okay, so what I'm going to do is reset your case about 30 days to give you some time to try to hire somebody. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you a reset notice.
Sign right here.
All right, let's go back to Judge Boyd and finish that up.
Just so it's clear in my records, and are you not revoking?
Thank you.
Thank you for the
Thank you,
clarification.
Mr. Judge.
All right, thank you. You're welcome.
And just like that, that's done. Since we really didn't do this last week, let's go to Louisiana. They're doing parole hearings today, I believe. No, excuse me, pardon hearings. I think they're pardon hearings.
Mr. Stapleton.
Present.
Mr. Prater.
Present.
Mr. Tillman.
Present.
Mr. Freeman.
Present.
Madam Chair, we have a quorum.
Oh, thank you. We will allow public comment on requests before any action item. So we'll just move right into regular business. And the first item is review and approval of the minutes from Monday, July 21st, which are included in your packets. Are there any corrections? I would entertain a motion to approve the minutes.
Make a motion to accept the minutes.
We have a motion by Mr. Tillis. Is there a second? Second by Mrs. Stapleton. Any objection? Hearing none, the minutes were approved. And so we'll move right into consideration of applications for clemency. In our first case is that of Miss Evans. Good morning. Would Miss Evans and counsel step up to the podium, please?
Yes, Madam Chair.
Come on. Good morning. Let me just read some identifying information into the record. So you are here to, well, first introduce yourself, Ms. Evans. Tell us your name and your current mailing address.
Dana Evans, 558 Hickory Lane, Jonesboro, Louisiana, 72.
Thank you. And counsel, would you enter your name to the record, please?
Robert Moore, 3576 Highway 371, Rego, Louisiana, Jonesboro, Evans.
Okay, thank you. So Ms. Evans is here this morning seeking a pardon with restoration of firearms. She has convictions in Lincoln and Jackson Parish, and I'm going to read through those for the record. Lincoln Parish in January 2012, contributing to delinquency of a juvenile. She received a 30-day jail sentence that was suspended. She was placed on 3 months probation. November 2012, theft less than $300. She received a 60-day jail sentence, suspended 3 months, placed on 3 months active probation. November 2012, criminal mischief and theft less in theft. She received 3 months active probation. That's right, yes. And 30 days parish jail for the theft, 60 days jail, that was suspended, 3 months active probation. Also in Lincoln Parish, November 2013, theft of less than $300. And then in Jackson Parish, we have February 2016, DWI third offense, to which she pled guilty to DWI second offense, received a 90-day jail sentence, and 6 months with credit for time served in probation. In April 2016, possession of Schedule 4. She received a 3-year hard labor sentence that was suspended. She was placed on 3 years probation, and theft, a 30-day jail sentence with credit for time served. Did I get all that correct?
Yes, ma'am.
Okay. So your case has been assigned to Mr. Prater. So before I turn it over to him, either you or counsel, tell us what is it that you're seeking today? How did you get in that situation? And why do you think we should vote favorable?
Madam Chairwoman, if I could just preliminarily note a couple of things. Miss Evans and I, not just a lawyer, I'm actually a friend. Been a friend for some time. Not on the family now for probably 15, 20 years. I practiced law in that district for 21, 22 years. And Miss Evans is currently employed with the Jackson Parish Sheriff's Department. She was employed now for 6 years with that department. If you'll notice the timeline of those cases, she's I think 52 years old, and this represents less than 10% of her life. It was a short period of time, addiction. I'm gonna let her tell the story of how that led up to that and where she's at. And Sheriff Craig will be investigating.
Hello. Yes, in 2012, I went through a lot, and I actually started on pain medication. That's what started. And then it went into alcohol. That lasted for about 6 years, I believe. And I was able to go into rehab in Florida. My family, and so I flew down right there. I was in America for 4 years. And since I've been back, I've had no alcohol, no controlled substances or anything. I live by myself. I am a widow since 2014. Never remarried. I have 3 boardless kids. My son couldn't be here, and then my granddaughter is there in the middle. My life revolves around them. The reason I am seeking a pardon is I can't do anything as far as the state of Louisiana to further my law enforcement. I can't get on the state computer. It's all kicking me out. So I can't do like driver's license and all that. I have to rely on somebody else. So I will never move up in my law enforcement until I receive a pardon.
Okay, and I didn't acknowledge your guests. Let me just, for the record, say your daughters Miranda Uplands and Chelsea Burns are here, and you mentioned your granddaughter Faith Burns, who are also here. I'm glad y'all are here. Thanks for being here. So, Mr. Prater.
Okay, good morning.
Then
Let's see, so the only felony conviction you have is having the 2 Xanax, is that correct?
yes, sir.
Okay,
Mr. Sheriff, I do believe there's a schedule of 2 and 4.
2 and 4?
I believe there's both those fools. Okay, there are 2. I apologize. I want to make sure that was correct. I think it's two convictions, but both are fools.
Okay, and you got multiple arrests, and they've been, when I say recent, they're recent by what we see a lot of times. We'll see somebody 40 years ago, they had some marijuana, they wanted off the record. So less than 10 years is kind of recent, but it's almost 10. It really makes it difficult to question you in front of your kids and granddaughter, you know?
Yeah, we could ask him to step out, Mr. Sheriff. That would be no problem at all.
No, they might, well, now that we brought it up, I was just wondering, how many theft charges did you have?
I believe it was like, 3, under $300. I was under the influence, not that that would ever make a difference, but I was, I had the money with me to pay for that.
Okay, and what was your drug of preference?
Percocets and Xanax.
Okay. All right, you got a good letter from your probation parole officer, very good, which we don't see those that often. They usually don't take a stance, you know, on something, but this one did, said you're a great model. You went through the drug treatment program in Florida.
Yes, sir.
Is that the only one, or did I hear that you'd gone through another one?
I went through a prior one, in Alameda at a Rabel. That is the, I left because my husband, they found overseas. And,
So you didn't complete that one, but you
no,
started.
sir.
Okay.
And I got right back out there. Picked up pretty much where I left off. And that was 2014. And then I entered the drug and rehab in Florida, June 7th, 2016.
Okay. And you got a good letter from your supervisor there at the sheriff's office. What, are you requesting your gun rights back also?
Yes, sir.
Are those completely necessary for advancing? In other words, can you still do NCIC and run everything on your lets, you know? Can you do all that without gun rights?
Yes, sir.
Okay. I don't have any other questions.
Oh, any questions? How did you start with the pain pills? Was there an accident or something?
Well, I was having back trouble, but no, ma'am. I pretty much went and had that prescription, and after that, I was, addiction does run in my family. My mother and dad both are deceased now, but my mother, she passed away at 30. And I can remember as a little girl, pain medication stuff. And it just followed suit. I'd have never, always when I was little, that I would never be hurt. One day, I looked in the mirror and she was there.
Mr. Moore, is there anything else you'd like to say to us?
Can I ask you a
Sure.
question? Do you do any follow-up treatment now, any kind of meetings or you in any groups, anything?
I did celebrate recovery and stuff for about, it was just 9 years, June 7th. And for the first 4 years, 3 or 4 years, I did.
Right.
Madam Chair, can I file a letter from the sheriff just confirming her employment currently with the sheriff? Yes, sir.
Yeah, would you hand it to the officer? All right, do you want me to see this? This is confirming her employment with the sheriff's office. This is from Sheriff Andy Brown. Mr. Tiller.
You said you have addiction problem in your family.
Yes.
How far back did your mother and father?
My mother, only my mother, not that that's, I may have got the addiction problem, whether or not she, I'm not saying that it was her, but I believe it's hereditary. And so, she passed away in 30, and she was 34. I was actually 12 years old. I was actually the one that found her. Her autopsy come back as heart failure, 34. The doctor said that was brought on from all the opiates and medication that she took, keeping saying the heart is still beating.
So, how old were your kids when you started on your trail?
Kelsey was 12, 11. 16 and she was 13, and then my son was 14.
So what do you plan to do to curb them? I want them to go through that same pattern.
Exactly, and they have every reason, so, to go through it, but they're great. Kids, all three of them are great. My oldest one is a school teacher. My son, he is a supervisor in West Texas in oil business. She is the assistant to the CEO of Origin Bank in Ruston. And all of my children, granddaughters have been on the principal's list since the day they started school.
No more questions.
I do have one. You were arrested, you had a prescription bottle of Xanax, and I guess maybe the hydrocodone.
Yes, ma'am.
So it was a prescription bottle in your name, and it said that it was expired, and that's why, you were arrested. So what was going on? Did you get like one prescription and you were buying it off the street and refilling it?
Actually, that's exactly what happened, but I was getting a prescription monthly. Dining, I believe, is what I was prescribed. When I would run out, which was very quickly. When you're an addict, 1, 2 is not enough. Sometimes 6 is not enough. So yes, I was buying them off the street and had them in the box, thinking that was gonna be a smart thing.
So how did it come to pass that you actually got the drug charge? It said that the prescription was expired.
One of my drugs, actually both of them being with Xanax. The Xanax, when I got arrested, I believe it was for the DWI. That Xanax was in the bottom of my purse. It was one, and I got charged with Schedule 4, which is right. Some of that I got charged with made me who I am today. It was consequences that brought me here. And the other one was a bottle that did not have my name on.
Okay. And it had.
Yes, ma'am.
Okay. That would explain that. Thank you.
May I add one thing? Sure. To answer, Sheriff Perry asked me to go talk for children in Mark present. For the last almost 20 years now that I've known Nina, she has been very transparent with me. I've known Matt for years and years. I've known Chelsea since she was a teenager. This is something that her kids and grandkids have known. She's been honest with him. I think hoping that cycle would change. Because again, I knew her when she was on drugs too. Because I've known her now for my whole career. I didn't represent her on underlying charges, but I'm a criminal defense lawyer in the neighborhood. So, you just know who the people you're dealing with are. And I've seen her now come full circle to here we are standing here and she's working for law enforcement. So it's really kind of a neat circle. But I would just tell her that she doesn't have anything from the family. They've known her struggles.
Okay. Well, I congratulate you on your bringing the kids up and what you've done and all. And my vote would be to grant your pardon, but without restoration of firearms at this particular time. It hasn't even been 10 years yet since your last. Also, grant without restoration.
Mr. Freeman?
You are right at the 10 years though. So I mean, that's kind of just a goal that we set is someone to be out 10 years and conviction free. But I'm also going to vote for your pardon. I think you've done a wonderful job and you were very honest today. I appreciate it. Without.
Mr. Tellus?
My vote is to grant without firearm.
Mrs. Stapleton?
Mine will be to grant without restoration.
Okay. And I do concur with my colleagues. My vote is the same. So on your behalf, we're going to make that recommendation to the governor. Should you be successful with that, you can come back at a later time, maybe for the restoration of firearms. Once more time. Good luck to you.
Thank you.
Congratulations, Mr. Brown.
Thank you. Yeah.
Approved?
Weird, right? That never happens on the first time out for the day. I'm so confused. Let's see how the fashion show's going.
Did you get someone hired?
No, ma'am, I did not.
Who'd you talk to?
I've actually talked to 3 or 4 more since last month. I talked to you.
Who?
I looked at my phone.
Yep.
One of them, he told me his dad used to run this courthouse before he, was one of them. So I've talked to Willard Law Firm before.
Uh-huh.
James R. Markin
Macon?
and Crimstar Law Firm,
Mm-hmm.
and then Walker Law Firm I've also talked to. And then Newark Firm, I also talked to them.
Who?
Newark. Newark.
I don't know who that is. Are they local?
Yes. Yes.
So did you just Google just now lawyers?
No, did get screenshots from when I talked to them, actually screenshot them so I'd be able to tell you who I
Okay.
talked to.
Okay. And you're working where?
I was working for at STI. The job lasted 2 weeks, and then the middle of last week we got laid off. But I just got a phone call from a shop in Coombs that a friend of mine working at. It's gonna be a permanent full-time job. I mean,
So what I'm gonna do this morning, I'm gonna have you fill out some paperwork to see if you qualify for a court-appointed lawyer, since you've done what I asked you to, and then we'll go from there. Obviously, if you get a court-appointed lawyer and your circumstances change, you might be required to hire one later, but let's look at it today. Make sure you fill out the paperwork that you're going to get completely and accurately, because you're going to swear under oath that it's true. If you'll step in front of the clerk, she'll give you that paperwork. Did we lose Mr. Adams already?
No, he's still working.
Okay.
Give me just a second.
See, Mr. Morian, are you ready to announce on Carolyn Whitaker? Carolyn Whitaker.
How are you this morning?
Good, how are you doing?
Good to see you.
You too. This is Miss, yeah, hot powers. Let me get to the right thing here. Good morning, ma'am. You're Carolyn Whitaker.
Yes.
And Ms. Whitaker is charged with aggravated sexual assault as well as injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, I've received all but one item of discovery. That's gonna be a lab report. Everything else has been shared to us. We had some discovery portal issues. I've had a plea offer that's been extended to me. I've had the chance to go over that with Ms. Whitaker and review the discovery that we do have. And at this point, we're gonna be rejecting that plea offer.
Okay, what I'll do, before you put it on the trial docket is have you fill out a plea bargain rejection.
Yes, ma'am.
They're on the tablet. If you'll get that filled out, then I'll go over everything and we'll get it set for trial.
Thank you.
All right, thank you.
So the fashion show is fairly tame right now in Judge West's court, but I realize that it might have migrated to a different courtroom within the building. Let's go over to Judge Holmes. Because this guy, at the very least, wins the loudest shirt of the day award.
Mr. Silva, your full name is Ivan Silva? Yes, sir. Mr. Silva, would you please raise your right hand? Mr. Silva, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Okay, Mr. Silva, you may put your hand down. How are you doing, Mr. Silva? I'm doing good. How about yourself? I'm doing fine, thanks for asking. Now, Mr. Silva, you're represented in your case by your attorney James Paget. And Mr. Paget, how are you doing? Doing well. Good morning. Good morning. Mr. Paget, do you waive a record in Mr. Silva's case? I do, Your Honor. Yeah. State is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing? Doing well, Judge. Thank you. You're welcome. Now, Mr. Silva, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ivan Silva, on or about August 18th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense titled collision involving damage to a vehicle greater than or equal to $200. Mr. Silva, do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Silva, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document? You recognize this document?
Yeah.
Okay. On page 2 of this same document, there's a set of initials, IS, on a line next to a box that's checked, no, the contender. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? I have another document on paper that's titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Silva, before you signed any of these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Silva, are you a citizen of the United States?
Yes, sir.
Seal for stage one.
No objections to stage one.
No objections. State's exhibit number 1 will be admitted. And Mr. Paget, you've advised and counseled Mr. Silva. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
Mr. Silva, your attorney, Mr. Paget, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Silva, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
The agreement in this case is the 6 months deferred probation with a $100 fine and 24 hours community service.
What's the court cost?
Remember I told you they charged me with this and orange card with the same because they came out and yes, they keep it. Why speech or I was thinking when I put myself in the person. Okay. It's the same day, the same.
Exactly. Okay. Mr. Silva, the state is offering that you serve 6 months deferred adjudicated probation During the 6-month probationary period, you'll be required to pay a fine of $100 plus court costs of $330 plus probation fee of $60 a month, your announcement fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $179 a month. Will you be able to pay the $179 each month?
Yes, sir.
You'll also be required to perform 24 hours of community service and adhere to the other standard terms and condition of this probation. Mr. Silva, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Silva, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Silva, if you successfully complete this probationary program, or this probationary period, this case will be dismissed. It will not result in a conviction on your record. And you may qualify for a non-disclosure, whereby your record will be sealed to the general public. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Mr. Silva, you're going to stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thank you, sir. Likewise.
All right, thank you. Eric Rashid.
Okie dokie, let's switch it up and go to Florida. So once again, we have this guest judge who's sitting in place of Judge Glazer. We gave him a nickname on Friday, but I can't remember what it is. So if you remember, put it in the chat. But apparently he's working through lunch, so good on him, I guess.
Yes, Judge.
Okay. For the possession of cocaine, your bond will be $2,000.
Just one moment. He's not here.
Oh, where is he?
They're looking for him. He's coming. I think he's coming. Is he here? He's present. He speaks English. Good morning.
Mr. Ronaldo, your bond on the possession of cocaine is $2,000. On the paraphernalia is $200. Good luck to you, sir. Larry Washington,
I'm sorry, Judge. What was the bonds?
$2,200. Are you Mr. Washington?
Sir.
Mr. Washington, you are not to return to Walgreens Pharmacy found at 159th Street, Northwest 27th Avenue. I'm signing a no contact order. You are before the court charged with petty theft, resisting without violence, trespassing, and making threats to a public servant. I find probable cause for all charges.
Judge, on count one, I would ask you to find probable cause at best for a misdemeanor threat to a law enforcement officer. They charged him as a third-degree felony.
It's making threats to kill the officer.
Which is a threat to a law enforcement officer.
Okay, what say you, State?
Judge, I do think that maybe it is charged incorrectly. This is charged against the public servant to influence performance. I'm
I
not sure.
will find probable cause for a misdemeanor as to count one, the bond will be $1,000. To count two, petty theft over two convictions or more will be 1,500. Resisting without violence will be 500. Trespassing would be 1,000. Good luck to you, sir.
Judge, Mr. Washington does not have funds for a bond, but he does have a place to stay. Would you consider house arrest as an alternate?
Where do you live?
Where did,
Northeast Third Ave, 199th Street.
With whom?
My mom at the Starling.
Judge, who was just convicted with petty theft on July 7th.
I saw that. No, ma'am, he needs to post a bond. James Oliver. Or Oliver Stephen James.
Your Honor, I have, our office has made contact with the victim father who does not want a stay away order, but is apparently unable to figure out how to be on Zoom. I don't know if Ms. Corey has made any contact with the family.
I have not. I just met Mr. James right now.
I don't have anybody here to take sworn testimony from, so maybe that's something that needs to be addressed in division. But I wanted to just bring that to the court's attention and to Ms. Corey's attention.
He has a house number. I don't know if you'd be able to call Ms. Sturgis.
We've had, oh, you want me to call and put them on? I can try and do that. You have a number?
Did somebody talk to you, ma'am? Or
Are
to your office?
Yeah, you're asking me, Your Honor?
Yes.
Yes.
Do you have any reason to believe the person who spoke with you was not the person who they claimed they were?
I do not have any reason to believe that, no, but I am not the person who spoke with the alleged victim here. Another individual in my office did, and I'm conveying that to the court. I would be okay if the court's inclined. Sometimes I can put somebody on speakerphone so the court can hear them. And
That's fine. It's fine with me.
So if the court's willing to just give me a moment, you said, Ms. Corey, you have a number?
Yes, 305.
That's different than what I have. So 305
944
944
6683. It's the house number.
And that is for Khalil James?
Yes, my mom and my stepmom and my dad.
Where do you work, Mr. James?
Well, right now I'm not working.
When's the last time you worked?
Well, I do like odd jobs. Cut the yard.
Who pays the rent of your house?
My mom and my dad. They're all retired. They get their social and everything. They pay all the rent.
When is the last time that you had a steady job?
Well, when before COVID,
And what were you doing then?
I was doing construction,
Well, why aren't you doing construction now?
like my back and stuff. I have arthritis, rheumatoid arthritis. So I really don't really work.
Well, did you get the arthritis after COVID?
Yes. Arthritis after COVID. My brother died, then I caught the COVID after he died, and blah, blah, blah. And really, I just stay home and take care of the yard and stuff, the pool, the yard and everything. Both of my parents are in the 80s. I kind of like take care of them, take care of the yard.
Well, let me tell you, you're not here for taking care of your dad.
Judge, I attempted to try that number that Ms. Corey gave me, but it's not going through based on its inability to accept calls from someone who, with no caller ID, Ms. Corey. I tried the other number that I have here in the A form and I'm not receiving anybody. I'm sharing with the court what I've heard from my office, but I also am not 100% confident in just issuing a modified stay order at this time based on the fact that I know there have been multiple domestic violence incidents with this defendant and this victim. And so I would be inclined to want to hear
What's
this
a standard bond?
on each of these counts. They
Yes,
are third-degree felonies, so it would be $5,000 each.
Your bonds will be $5,000 each. You are to have no contact with your father. I would appoint the office of the public defender if things change. Then
Mr. James indicates he has another place he could stay away from his father pending this case, but he does not have funds for a bond. Would your honor consider house arrest with the stay away order?
no, ma'am. Augusto Marino.
That was $5,000 each case, your honor.
Yes, ma'am.
Thank you.
Thank you. Yeah, I have it here. Reset A4 Ward D. I don't know what that means.
Yesterday they.
NBC, your honor. Medical.
Oh, he's there. No. He's in a hospital.
You wanted to reset it, Ms. Perry?
Yes, please.
Mr. Marino? Yes, please.
We'll pass it to tomorrow.
Thank you, Judge.
Stanley Fakir. What do you need? Mr. Fakir, you're charged with possession of cocaine, possession of paraphernalia. State, what's your recommended? Does he have a pending one? Oh, he just got convicted in March.
Correct, he just got one. I'd ask for standard bond here.
Which is?
5,000, sorry. Well, 5,000 count one and count two would be 500.
5,500 out of the bond.
Judge, standard bond is 2,500.
Oh, it is, Judge. It's an F3, but it's a non-violent, so it's 2,500.
2,500 and 500. Angela Khalif.
3,000 two bonds.
Angela Khalif. Mr. Khalif, you're charged with grand theft auto. Find probable cause.
But she's charged with a first-degree felony. There's no value indicated. It should be a third-degree felony, which would be $2,500 standard bond.
Because here you have a warrant out of Nebraska?
Yes, sir. Yes, Your Honor, I apologize.
There's no allegation as to what kind of vehicle this was or how much was it worth or it was.
Judge, it indicates it's a 2023 Slingshot.
Well, I wish I could take judicial notice of what a slingshot cost.
I could not tell the court either.
Yeah, $2,500. You are to stay away from the Fontainebleau. Oh, man, I apologize. We need a bigger. Jorge Martinez Morena,
I'm sorry, Your Honor, we cannot hear. What was the bond for Mr. Khalif?
2,500.
2,500, thank you.
Jose Martinez Morena. You're charged with possession of crystal meth.
Spanish interpreter, please.
Y la acusación es en posesión de metanfetaminas, cristal.
I find probable cause.
Encuentro que hay causa probable.
How long have you lived in Hialeah?
¿Cuánto tiempo ha vivido usted en Hialeah, señor?
De 2021, de que entraste por ahí.
Since 2021, when I came to this country.
That's for pretrial.
Who do you live there with?
¿Con quién vive usted ahí, señor?
Solo.
By myself.
Where do you work?
¿Y en dónde trabaja?
Instalación de puerta y ventana de impactos.
Perdón, no escuché.
Instalación de puerta y ventanas de impacto.
Guys, installation of impact windows and doors.
I'll refer you to pretrial services with an alternate bond of $1,500.
Lo voy a referir a servicios previo a juicio con una fianza alterna de $1,500.
John Barrett.
Okay, everybody, the vote was close, but you voted in favor of Dungeon Court, so we'll finish our day out there while Ellie keeps me pinned down. So let's do it. The worst production value, the worst audio, the most fun, ladies and gentlemen, Dungeon Court.
Not his obligation, he's being a big help. Participates well during counseling and group sessions. I believe Mark truly does have a desire to maintain sobriety, stay away from alcohol for good.
Well, trying to, sir.
Well, I've known you for a long time, and
too long.
I wasn't expecting this kind of report on you, but I'm really happy and glad you're doing so well. That's amazing, because it's been a problem for a lot of years, right? So you can always, folks, you can always change. They say old dogs can't learn new tricks. It's not true. Mark and I are both old dogs. You can learn new tricks. You just got to work at it. You don't give in. Okay, good job. I'll set you a new hearing in about a month or so. Let's make it September 19th. September 19th. Okay,
Thank you, sir.
See you back in a month.
Right.
A little over a month.
But anyway, like I said, I like it beer.
Arnold with after you. Edward Ferris, 24537. Is that the council's?
Morning, Your Honor.
Good morning.
So, yes, they did in fact
Class him as outpatient. He has not really, he's made his first appointment, which is to establish his outpatient schedule. So that's where we're at.
Okay, well, that's disappointing because I expected more to have happened by now, right?
Well, I mean, that was just last week, Your Honor.
Okay, all right, I thought we had more time. So when's his first appointment?
4 days a week. He'll be attending group 4 days a week, Your Honor. So he'll be starting groups this week.
And one individual a week and one case management session a week.
All right, well, let's check in. I'm not gonna go a full month for him. Come back and see how he's doing. The 20th, no, I'm gonna make it the 18th. August 18th, so 2 weeks.
Your Honor.
Yes.
Is there any way you can push that out till after the 25th?
Are you not available, or?
I'm going to be on vacation.
Can somebody else give me a report?
Absolutely.
I want to check on him. So let's keep it the 18th. Nobody has to actually appear from the counseling center. Just have them send me a report by email or text or fax or however they can get it to me.
Would Zoom court be okay, Your Honor?
Yeah, that's fine.
Okay.
August the 18th, 9 o'clock.
Thank you.
Kelly Fitzpatrick.
Yes.
1427.95. Community service done. You got still your funds to pay.
I have the money with me. They said wait till after to pay
You
it.
gonna pay it off?
Yeah, I have the full.
Okay. Well, the way I do this now is because people have told me that and then just walk out the door and don't pay anything. So they still give you a new date. If
Okay.
you pay it off, you don't have to come back.
Okay.
So I'm going to set it for September the 2nd, which is a Tuesday.
Okay.
If you paid it, you don't have to be here. 9 o'clock, September 2nd, go see the clerk. Okay.
Okay, thank you.
Anthony Gianmarco, 24/7/24.
Oh, okay, well, I'll check that.
Your Honor, I had a, yeah, he came in Friday.
And?
Assessment, yeah, and that's the only time he's done, came in.
Yeah, because he was at recovery ranch at one time.
Yes, Your Honor, I was.
Okay. So is he going to be outpatient then, or?
Yes, sir.
Your Honor, if I may, I have a note. Mr. Gianmarco was ordered on June 30th to have some community service done before the next hearing. He has not been here for community service.
Okay. What do you say about that?
I'll have it done, Your Honor. Honestly, I got sick for a little while and then I've been back and forth to work. I just haven't had much of time. But with everything was going on between switching from the ranch to recovery services, I have enough time to come down here and do it. My schedule's changed up. I don't work during the workday no more. I work during the weekend. So
Where are you working?
I'm working at IHOP. I work from Thursday to Sunday.
Okay. All right, well, give me a commitment of a day you're going to be here.
What days are the community service?
Every day to Sunday.
Okay, so we can do Monday or Tuesday and Wednesday.
You'll be here tomorrow morning.
Yep. Yeah, I can be here tomorrow morning. Yeah.
Okay. 7:30
Yeah.
Yep.
a.m.
Yeah.
Not p.m. 7:30 a.m.
Yes,
All right. Since you're off on Tuesdays, I'll set you for September 2nd also as your next review hearing.
Okay. Thank you, sir.
9 o'clock.
Okay.
Amanda Henson, 25/6. Amanda Henson. It's not here. She's done 1 day of community service. That's it. That's the only thing she's done. Be a benchmark for failure to do. Destiny Gerald is here. Okay. A little bit more community service.
Yeah, I would.
September 8th, and that's a Monday. Will be your next hearing. See the clerk to make your payment.
Okay.
Gary Kazee.
Good morning, sir.
Good morning. 14/309, 16/166. been making payments, you made a payment in July, do you have a payment today? That's all you have is fines and costs.
Yeah, I think she got done whatever she does, it's either online or,
So you think you've already paid something this
yeah,
month?
I think she already paid $40.
All right, September 2nd is your next hearing, 9 o'clock. That's a Tuesday, September 2nd.
Thank you, sir.
You're welcome.
Cody Mead, Anthony Merritt, Derek Newell, Christopher Roadcap, Ricky Sowers, Michael Roberts, William Turner.
Cody Mead.
Yes, sir.
You got this. Okay, the old cases are 23-152, 22-2101, 22-4690, and just have fines on those. So, are you making a payment today?
I ain't gonna be able to, Your Honor.
Okay. You got a new case, 25-1873. That alleges that on July 31st at 11:58 p.m. in Perry Township, I'm sorry, 11:58 a.m. Perry Township, you were driving a vehicle with a suspended license. It's a 12-point suspension, so that's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine, and you were not wearing a safety belt, so that's a mandatory $30 fine if you're found guilty on that one. You understand those two charges?
Yes, sir.
How do you plead to them?
Guilty.
Okay, I have a report from the officer saying, as the vehicle passed my position, I noticed silver buckle hanging, and there was no diagonal strap across the driver's chest. The defendant admitted he was not wearing a safety belt. He was warned for, it says he was warned for that, but he put it in the, there is a citation for not wearing a safety belt. The driver was under an FRA and 12-point suspension. Claimed to have insurance. Was instructed to present it at court, was polite and courteous. Do you have proof of insurance? Or?
I do, but I don't know how to look it up on the phone, to be honest with you.
Okay, well, here's the way it works. You need to figure it out because, I mean, you've got a deep problem with your driver's license anyway. You don't want to dig the hole deeper, and every time you get stopped, if the officer says, show me your proof of insurance, and you don't, and checks the box on the ticket saying no proof of insurance, and then I don't change it, I can change it now. Like if you've got the proof, I can say, put it in the computer that he did have proof. But if I don't change it, and it goes up to the B&B in Columbus, they suspend you all over, and every time they suspend you, you get another, you get points, and you get another reinstatement fee, and it's like digging that hole deeper and deeper and deeper to get out of. So
Your Honor, whenever I got pulled over, we showed him the proof on the phone. She did with Allstate. She showed him that. I didn't, or I would have brought the proof in the day.
Well, that's not what he says in the report. I mean, so I'll let you. Do you think you can dig it up? Or who's she? He says she showed it to him on
The wife.
Your wife?
Yeah.
Is she here today?
No, she's at home with the babies.
Okay. Well, let's do this. I'm going to set it for a sentencing here. It's worth it if you've got the proof of insurance to bring it in here and show it to me. So bring her to court or have her print it out or whatever you need to do to get the proof of insurance and come to court, and I'll sentence you after I get the proof of insurance. I mean, you got these other cases anyway, so you're going to be coming back.
Yeah.
Okay?
Yes, sir.
You gotta, I mean, look, if you're gonna, you shouldn't be driving because you don't have a driver's license, right?
Yes,
I mean,
sir.
this is a fairly minor reason to get stopped, and for years, driving without your seatbelt on was not a primary offense, and what that means is they couldn't stop you just for that. They had to have another reason to stop you, but then if they saw you weren't wearing a seatbelt, they could cite you for it. Now they've made it a primary offense, so they see you drive without your seatbelt on, they can stop you just for that, even if you're doing everything else exactly right. Just not having your seatbelt on is probable cause to stop your vehicle. And that's what he said happened here.
Yeah.
So, and it's a smart thing to do. I mean, okay, is there a possibility you run off 31st Street Bridge and you drown because you couldn't get your seatbelt off? Yes, but that's highly unlikely. If you have a wreck, out of 100 wrecks, 99 out of 100, you're going to be better off for having a seatbelt on than not having it on. So it's a smart thing to do, and the law requires it, and it's going to keep you from getting stopped now. You got it on. Does that make sense?
Yes, sir.
Okay. So what I'm going to do, I'll just set this for a sentencing hearing with your other cases, because your other cases you're still working on. Bring me back the proof of insurance the next time, and I'll sentence you then when you got the proof of insurance, and then I can tell the DMV, yeah, he did have insurance. Don't give him another suspension.
No.
And if you don't have it, then it's going to go on. It's not going to be me that suspends you. It's going to be the Ohio BMV, because that's what their rules are. Okay, you understand?
Mm-hmm.
So it's out of my control, but you bring me the proof, and then I can tell them, and that'll keep them off of you. Okay, are you working now?
I am. I subcontract roofing.
Oh, so you're working for yourself or working for
Yeah,
somebody
no,
else?
I work for myself.
So you can come on whatever day I said, or is there one day it's better for you than others?
I can make it for you.
Let's do it this 2nd of September, because that's a Tuesday, and it's going to be a really light day, so we'll get out of here quicker. So September the 2nd for sentencing on this one, and review on all the others.
All righty.
Okay.
Thank you, sir.
You're welcome.
Sorry, guys.
Anthony Merritt, 08-2201, Anthony Merritt. Well, I've got this down. I've got both sentencing and a review, so I'm not sure which it is. Doesn't look like there's a bond up. To make it sentencing, but since it says, one section says sentencing, the other says review, so I'm going to pass it and we'll call it at the end of the docket. If he hasn't appeared by then I'll issue a warrant. Derek Newell.
Yes, sir.
22-12-29. Okay, you got a report, from Phoenix Center saying you completed their program and they gave you a certificate of completion.
Yes, sir.
You're putting in the file. You got to do your community service and pay your fines.
Yes, sir.
You have any payment on your fine today?
I don't. I started back with Mr. Roofer, and I'm living in South Point now, above his office.
Okay.
I started back here in the middle of last week. So.
All right, so you have, since you were doing treatment, you did probably have an ability to earn any money.
No, not at all.
Okay, we'll work with you on that. What's your work schedule now?
Monday through Friday, and then it's just like sometimes the weeks I'll sell roofs. No, I'll make it work. Just some more. Of course, the mornings will be fine.
September 15th, so that's a Monday, 9 o'clock for review. September 15th.
Thank you so much. All right. Thank you, sir.
You are. Christopher Rocat is here. It is 21-11-72 and 23-646. He's done some community service since his last hearing.
Finally, just got back to work too.
Okay. Are you paying anything today?
No, I just started last week.
All right. I'll set your, where are you working now?
Just, helping people.
Okay, so you can come on, if I set it for a Tuesday, you can come.
My fiance's got a surgery, in September, so
What day?
I ain't real sure yet.
Well, let's set it for the 2nd, that's the first, right, the 1st. So September 2nd will be your next hearing,
Okay.
9 o'clock. Ricky Sowers, 2544, Ricky Sowers. Not here, hasn't done anything on the case. Set for review today. Bench warrant issued for failure to appear. Michael Roberts, 2552. Hasn't done anything on the case, hasn't appeared, so there'll be a warrant issue. William Turner, 24653. Are you William? This is just a fine only case. You have a payment on your fine status?
I did last night.
Okay, I see, and it is showing. Mondays or Fridays?
Doesn't matter.
September 15th is your next hearing, 9 o'clock. Okay, that finishes the reviews. We're going to start the arraignments now. So if you're here, anyone out in the hall that has...
All right, friends. Well, we've reached that time of the day where we must say goodbye. But I hope you had fun today. I know I did. And look forward to seeing you again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, half an hour earlier for channel members. That'll be the next time we're live, but we will be posting videos throughout the day today, so be sure to keep an eye out for those. Big thank you to the sponsor for today's show, Aura. Please do check them out at aura.com/TCF. There's a link to that in the description. Also, check out Michael Groff, our other sponsor for today, and a link to his channel as well as in the description. But we'll see you all tomorrow. Again, hope you all had fun, and yeah, go make yourselves a great day. Take care. God bless.